Let me take this opportunity on this second day with the Advocate Mkhwebane to welcome the members here on at M46 and on the virtual platform. Welcome the Public Protector with us here at M46, together with her legal team led by Advocate Mpofu. And I can notice that both of them have gone back to their roots. We envy that. Let me welcome the evidence leaders, Advocates Bauer and Mayosi, members of the media with us, our entire support staff, the people who brought us here, the members of the public in your various platforms. Welcome to day 2 of this session. We will immediately not waste any time and hand over and ask Advocate Mpofu to kickstart the proceedings. Are you settled, Advocate Mkhwebane? Okay, thank you. Over to you, Advocate Mpofu.
Thank you very much, Chairperson. Good morning. And thank you for those remarks. Namhlanje ukenza ubuza ngesiXhosa ungandivaya kandiva. No. Now, good morning, Public Protector.
Good morning, Advocate Mpofu Lochan.
Yeah. Ninjani. Thank you. All right. Now, we left it off yesterday where we said that today we're going to get into, shall we call it, the meat of the issues. The term that I borrowed from the chairperson yesterday was landscaping, and it was a correct term, and we're happy that the chairperson allowed us to do that landscaping, because as I always say, once you set the scene, it might look like a waste of time, but actually it saves time, because it means now when we get to the actual meat and the charges, we don't have every time to go back to that overview because the foundation has been laid. But having said that, Chairperson, it's inevitable that we have to anchor the evidence back to the overview without over elaboration. I mean, we're not going to take a day every time we have to do that overview. So maybe, Chair, before I do that, if I can just address a few issues to you directly. One is the issue that you discussed in your meeting last week about the funding of the legal team and all that. We just wanted to record, Chair, that we know that it's not your issue, but you were simply copied like everyone else. But just for the record, that it's a matter that we know we're seized with. Unfortunately, the last few days have been hectic with statements and courts and so on. So we'll take advantage of the few days break and be able to respond. Then, Chair, we also want to flag the fact that we are concerned about the length of the evidence and the number of days that have been provided. But again, we'll assess that. I think after today in particular, we'll be in a better position to engage at this level or at the level of the back room as to what, so that by the time we come back the next week, we'll have a sense. I know either to say how much longer or shorter. I know you want it to be shorter. But we'll be able to assess, particularly after today. Thanks, Chair. Now, Public Protector, I was saying that.
Thank you for putting those measures on record. They're well noted. Thank you.
Thank you, Chair. Yes, I was just saying to the Chair that we will now and again go back to the overview, but really for the purposes of making progress. Because remember, every charge will have its own quote unquote mini overview, because that particular report has got a particular context. But we're not now going to go back to the broader issues, except for the purposes of addressing a particular charge. So that's the mode we're in now. So in that context, I then want to recap that yesterday you explained to the chairperson and the committee why it is that in your resequencing of the charges, you are going to start with the CR17 Busasa matter. Correct?
Correct.
Yes. And you explained, I think your words were that this is one of the matters that this whole thing is all about, that have brought you here in the context of the words in the Nkandla case, correct?
Correct.
All right. So we are now then going to zoom into that particular charge, but I thought again, just to put it into its context, we, as we did when we were dealing with this charge with Mr. Matabuche, we always have to keep the eye on the ball, really. And I think, Chairperson, I'm now addressing you, Chair. This kind of, you know, we're all in unprecedented territory. And as we said, all of us have a responsibility to shape this. Nobody else has done this before. So we need to find a methodology that works for all of us, but one where we're on the same page here. Unfortunately, there's no precedent that we can look up to. So I think we owe that to the nation anyway, to try and design a framework. So in that spirit, then one of the things that I think we need to do is always to focus on what we're not doing, if you know what I mean. So for example, Chair, we are not here when we talk about CR17, Busasa. It's important to communicate this frankly to the nation and to everyone, that we're not here to redo the Busasa report. Otherwise we'll be here for the whole month. Yeah. Neither are we.
Very important point.
Yes. Neither are we here necessarily to second guess the findings or try and amend them, because the report is the report. We can't change it. And thirdly, Chair, we're not here to rewrite the judgment either. The judgment is the judgment. So the example I thought of to make this point was, let's assume this CR17 thing had featured in the Zondo Commission, and then there was some new evidence, like video evidence of money being given and so on. This committee cannot be concerned with that, because this committee is looking at a point in time, which would have been before those revelations or whatever. So we couldn't then come here and say, no, Chairperson, let's play this video of what happened in the Zondo Commission to show that the public protector had this. That would be a false methodology. So what are we here for? We're here for the simple task of looking at the charges that this public protector is facing before this committee. And those charges have been defined by Parliament, not by the committee. They've been defined by the Parliament. So we have to look at that definition. We don't have to reinvent the wheel. We don't have to or follow our hearts or whatever. Misconduct is what misconduct that has been defined by Parliament. If we want to change it, we'll have to go back to the House and change that definition. But for now, we're all confined to what it is. So that's the first level, which I think we must always keep at the back of our heads. The second level, Chair, which really is where I'm going now, is then having understood that what is misconduct, what is incompetence, and what have you, we then have to say, as we're doing now, which charge are we now dealing with? And we're dealing with essentially now 11.3 and 11.4. Then we look into the mechanics of that charge and the specific allegations. And that's all really. And then the committee in the end will say, this charge and this charge, yes, no, or whatever. And maybe the last point, Chair, is that we also, although it's not easily separable, there's no point in putting the legal argument to you at this stage, as it were. We must try to get into the facts. Yeah, we will get an opportunity to do closing arguments, and then we'll say, no, this fact means that, this fact means that. Yeah, it's not always easy to make that separation, but we must strive to if we're going to make legal argument, it's really just to plant the seed, but not to focus. So that's, Chair, is what how we propose to approach this, so that we don't waste time on, as I say, on what this process is not about. All right.
Suppose Advocate Mpofu, Advocate Power.
Sorry, Advocate Mpofu, so that,
No problem.
that we're on the same page. And so that we have some agreement on the ground rules, because it seems as if we could make common cause, and the common cause would be, actually, we're not rehashing the facts, we're not redoing the report, and we're not looking at new evidence on the facts that emerge subsequent to the motion being lodged. Is that how I understand you to say?
Sorry. Yes, more or less, except the first one. The first one is, I don't, that's not what I said. The facts, I'm trying to say we must focus on the facts at this level. That's what a witness is here for. So it's inevitable that sometimes we'll put legal propositions and so on, but really we just want the raw facts. The legal argument of what is the meaning of those facts and what it is not, you and I will debate at the end. So that's the first thing. But the rest of what you said, I agree. We don't have to, we can't redo the report because it's there. It was done, it was signed and dusted. Neither can we rewrite the judgment.
There's just two issues that I thought we must just clarify. On the legal issues, some of the issues of misconduct and incompetence that appear do emanate from legal propositions,
Of course,
that I may have to put to the public protector when it comes to that
Sure.
point. So I may want to say that you're upfront so that you're aware in case you want to canvass those issues.
No,
with a
Chair,
meaning that
I accept that. I
Right.
accept that also on the basis that this is not just a witness, it's the public protector. The reason why she's the public protector, all this the stuff we're going through yesterday. She's legally qualified. That's one of the qualifications of being a legal public protector. So inevitably, when you put questions, or even members, no one can stop them from testing. Well, how did you come to this conclusion if you had this evidence? That kind of thing.
Sure. Thank you.
And then the second thought that I had as you raised this, Advocate Mpofu, was there is, of course, the exception of where an appeal judgment only came out after the motion
Yes.
had already been finalized.
Yeah.
Even though the High Court judgment existed at the time.
Yes.
That
yes.
obviously that bears on
Yeah.
on some relevance,
Okay.
irrespective of which way that goes.
Yes. Chair.
Okay, thank you, Advocate Bauer. Oh,
Yes.
over
Thank
to
you, Chair. Again, this is very important. And ordinarily, as I say, because this is unprecedented, ordinarily we would have this kind of exchange when we do the legal argument.
Yeah.
But Chair, with your permission, I think it's important that you allow it, obviously, within bounds here, because it focuses, in my view, it will focus all of us, focuses the witness, focuses the members, and it will limit unnecessary evidence, so to speak. So then maybe to respond directly to the point you're making. Well, you are saying that when is the point you're making for now or for the legal argument?
No, I think that I accept that this is not a hearing. I am in agreement with you that we are not here for the committee to reevaluate all the evidence that informed the public protector's reports. But there are judgments that have been handed down, which is referred to in the motion.
Yeah.
And then
which were superseded by,
which are then superseded by appeal court judgments. Let's take the SARS unit judgment, for instance, whereas at the time the motion was written, there was a High Court judgment. You guys had appeals pending. There has now been finality in respect of that.
Good.
So that has some relevance or bearing on it. And in the same way, if the full bench decision in the Western Cape that you argued at the Concord, or it gets argued, comes out, obviously that there's now a finality on that issue that has a relevance to which should be referred.
Yeah, no, I understand, Chair.
So you're done, Advocate Bauer, so that we allow him to start.
Yes, Chair. Before I start, let me just respond to that and just give you an assurance, both to the committee and to Advocate Bauer. We're not going to be taking technical points at the end and say, and the SARS issue, Chair, is a good example. Both SARS, I think, and CX. So we're not going to come here and say, oh no, you can't talk about the Constitutional Court judgment in SARS, because when Ms. Mazzoni drafted her motion, that judgment was not out yet. We're not going to do that. If we were going to do that, really, we would be making a mockery of this process. I know that in the actual motion, as far as the SARS matter is concerned, that is the commissioner for SARS, the charge that is, or rather the judgment that is cited, even in the amended motion, is the High Court one. And as Advocate Bauer says, that was because the Concord one had not yet happened. But it would be ridiculous if we're now going to say, well, the charge is the four corners of the charge. Because actually it would be foolhardy for us to do that. Because what if, for example, in one case where the Concord would have come to agree with us, then if we're now going to say, no, you're confined, it means even us, we won't be able to take advantage, quote unquote, of any favorable finding. But so should the evidence leaders be able to use any subsequent finding. You can be sure that we're not going to do that.
Okay.
Okay.
Thank you, Mbofu. Let's not eat too much into your time.
Yes.
Please.
Thank you. Thank you, Chair. Right. So now, Public Protector, what I want to do then is to start with this session by taking you to something that is effectively the one of the of the standard methodology templates that is contained almost in all your reports. And it's something that I like it for simplicity. Because sometimes, lawyers like to complicate things unnecessarily. And it is that template that you use for saying what happened, what should have happened, and so on. And I think it makes it easy even for members of the public to follow how you do things. Can you maybe assist the committee as to where that formulation came from? Did it come from you? Did you find it there already? And what does it entail? So.
Thank you. Good morning, Chairperson, members of the committee, evidence leaders, the staff of Parliament, my family, members of the public protector staff. This formulation, it was developed by my predecessor. It's one of the things which, when we were deliberating at the think tank, I said it's well crafted and indeed it's simplified. It's something which we can continue using because it's true that when it's not broken, why fix it? So that's what we are using, and indeed it's very simplified. And I must indicate that it's what we've been doing, and I think that's what I will be comfortable today to deal with, to answer the charges and to deal with everything I relied on at that particular time to come to the conclusion of all these reports.
Yes. And maybe before we even get to that, just to situate the discussion that we just had now with the chair and the evidence leaders, for the sake of completion, for you to confirm that that is the framework that we will be following in dealing with your evidence and arguments and what should guide the committee when it does its report. Would you confirm that framework, or want to add something to it?
Yes, I wanted to say you are speaking over me and I'm sitting here, but we discussed, indeed, that's what we'll be doing. We are not starting the investigation, but what committee members and the public should know, and which I'm saying, I will have to take the public into confidence on what was happening when all these matters were investigated.
Correct.
To prove the issue of competence and to prove the issue of doing my work without fear, favor, or prejudice.
Yeah. Okay, good. Thank you. No, that's exactly why I think the chair allowed me to put that question, so that we don't have some side agreements which don't which you can say later, well, that I was watching you talking, and that's not my approach. Okay, thank you. All right, so now that we've got that out of the way, which I think will save, as I say, a lot of time and a lot of bickering. Yes, let's go to page 550, Tsepo, so that we're all on the same page as to what we're talking about now. Big 550, small page 54 of the public protector statement. Right. So I'll just read it out, Chair, for speed. 124. Yeah. So that's for the benefit feet of the members. That's the matrix or template that we're talking about. So it says, like every public protector investigation, the investigation is approached using an inquiry process that seeks to find out, 1, what happened, 2, what should have happened, 3, is there a discrepancy between what happened and what should have happened? And does that deviation amount to maladministration or other improper conduct? And 4, in the event of maladministration or improper conduct, what would it take to remedy the wrong or right the wrong occasioned by the said maladministration or improper conduct? Very simple way of explaining a complicated process. Right. So, and we've already, you heard in the other exchange that all that for the purposes of this exercise is not necessarily to redo the report, but to what we're really inquiring into, if you like, is what was happening in your mind, to put it simplistically. Yeah. Were you motivated by, if you made a mistake, for example, was it an honest mistake that anyone can make because we're all human? Or was it motivated by some intention either to target this one or to exonerate that one? We've had that discussion with witnesses like Ms. Mkhwebane and Mr. Matabuch. You understand that?
Yes, I understand that, SC, and Chairperson, I will propose that you also, when you go through paragraph 125 and 126,
Okay.
which influenced what was happening when those investigations were conducted
Yes.
by the investigators.
All right. Yes, I'll read that into the record as well. It says the 125, the question regarding what happened is resolved through a factual inquiry, relying on the evidence provided by the parties and independently sourced during the investigation. 126, the inquiry regarding what should have happened focuses on the law or rules that regulate the standard that should have been met to prevent improper conduct and or maladministration as well as prejudice. 127, the inquiry regarding the remedy or remedial action, which we dealt with yesterday, seeks to explore options of redressing the consequences of improper conduct and maladministration where possible and inappropriate. And I think for the sake of completion, we read 128 because that's important. It is in the important case of public protector versus bail and guardian, the SCA made it clear that it is the public protector's duty to actively search for the truth and not wait for the parties to provide all the evidence as judicial officers do. Again, this is a point that's been repeatedly made here, but I think that should assist then the members to situate the core of what you do as public protector. Thank you. Right. Okay. All that's enough overview material for today. Then we have to focus on the specific charge and the specific rather specific charges that are relevant to the CR17. All right. Now we know that and I'm paraphrasing just to save time, charges 11.3 and 11.4 really focus on allegations of, let's call it favoritism on your part. You favor this one and you disfavor that one. I'm putting it very roughly, but you get what I'm saying.
Yes, I do.
Sure. Thank you. All right. Now, take us through, please, then walk us through without going into blow by blow. You made the point yesterday, again, we won't revisit that you don't go around standing in the street and say, hey, please, I'm looking for complaints. or I want complaints against Mr. Janji or this one. People complain to you and then you have to act on that, correct?
Correct.
Right. So then take us through what happened in this particular, how did this particular complaint come to your desk?
Yeah, okay, thank you. The investigation of the CR17 report, I think that's what we will call it, CR17 or Busasa report, emanates from my decision to investigate and report on the CR17 campaign of the then Deputy President, Cyril Ramaphosa, for the African National Congress leadership in December 2017. So this was a complaint lodged by Mr. Mkhwebane during November 2018. And in January 2019, another complaint was lodged by Mr. Floyd Shivambu.
Okay, sorry, I know everyone knows these people, but for the record, with what capacity were they, I'll ask a leading question. Were they members of parliament as prescribed in that act?
Yes, Mr. Mkhwebane was a member of parliament and the leader of the Democratic Alliance.
Thank you. Just a pause, but Protector Advocate
Sorry,
Bauer.
Advocate Mpofu, I don't want to interrupt you.
Sure.
But it seems to be that you had paragraph 250, 251 of the statement. Would it assist the members if we put that
If we
on the
put it
screen?
on the record, okay.
Okay, thank you.
Chair, can I do that?
Thank you. Go ahead. You can switch it on again, because when the third one comes in, it automatically goes
switch
off.
Yes, thank you, Advocate Bauer. Yes, I think that will help us with this session. This part of the questioning. I'll just put it on the record. The members will be referred to 250 and 251. That's on page 610 of the statement. Small 114 tempo. Yeah, and it reads as follows. How this charge is formulated makes it difficult for me to respond. It gives an impression that the complainant was on a fishing expedition. This charge is not only confusing, but prejudicial to me as it fails to deal with specific allegations or even name the politicians whom I allegedly disfavored and or favored. Okay, that now goes to 11.3 and 11.4 per se. We confirm that, Papa Prater?
Yes, I do.
Thanks. Then the next one is 251. The CR17 report emanates from my decision to investigate and report on the CR17 election campaign of the then Deputy President for the ANC leadership in 2017, which would inevitably lead to the presidency of the Republic. During November 2018 and again January 2019, I received complaints about President Ramaphosa. The first complaint was from Mr. Mkhwebane, the then leader of the DA. Complaint was related to the relationship President Ramaphosa, or rather of President Ramaphosa with a company called African Global Operations, formerly known as Busasa. And the following information appeared from Mr. Mkhwebane's complaint. Okay, I won't read the details of the complaint. Yeah. But that's the background. That's how, in answering that question, I think Advocate Bauer is correct. How the matter came to your desk is then captured in those two paragraphs, correct?
Yes, it's correct.
Okay.
And especially because they were members of parliament and they are the ones who are allowed to lodge a complaint under the Executive Members Ethics Act.
Right. Okay. Now, and again, until there's an objection, I'll lead on the non-controversial background. I'll ask you in the form of leading questions. It is indeed so that, and most South Africans know about this, that really the origin of this whole thing was a parliamentary question put by Mr. Mkhwebane to the president in the normal Q&A sessions, which ironically had nothing to do with CR17 or anything of that sort. It was about at best allegations of some money coming from a questionable company to the president's son. That was it.
Correct.
Yes. Okay. Again, Chair, I'm not going to read the actual question and the answer. It's all there. It's in the report and it's in the statement here. But essentially, what Mr. Mkhwebane, the leader of the DA, wanted to know was about the payment of a certain amount of 500,000 rand by this so-called Busasa company to Mr. Andile Ramaphosa, correct?
That's correct.
Right. And I think this is very important because I think had the matter ended there, that would have been, we would not be sitting here debating that matter. Because the president answers questions all the time. And that's the, the question and it's answered and that's the end of it.
That's correct.
Yeah. But in this case, a couple of weeks later, the president himself, and this is where the CR17 comes into the picture. The president himself then wrote a letter to the speaker to say, no, that answer I gave was wrong. About, I looked at my son in the eyes and all that, and I'll take him to the police station. Actually, that 500,000 was paid to the CR17 campaign, right?
That's correct.
Good. And that's how we then got to the rest, as they say, is history.
Okay, just pause. Advocate Bauer.
Chair, I understand Advocate Mpofu's leading the witness for purposes of saving time and wanting to get through facts. But there are times when Advocate Mpofu's characterization and adjectives are different to what's in the affidavit. And I just want us to be clear that we don't describe evidence to the public protector or whether it would create some confusion later. So I just want to raise that to make him a.
All right. Okay, Chair, yes. First, well, I agree with the fact that it's a leading question, but it's not a leading statement. That's why it's a question, so that the witness can confirm. If the witness thinks that there's something wrong with an adjective or whatever, she can do so. But also, if Advocate Bauer feels so, I think she's also allowed to point it out. Yeah. But I get what she's saying, that there might be a particular nuance in that's what's wrong with leading questions generally. All right. So subject to that, you accept, let me put it as dryly as possible, that subsequent to answering the parliamentary question, the president sought to correct it by putting what he was presenting as the correct facts. I think if you do it like that without adjectives, do you confirm that?
Yes, I confirm that, and I think that is also captured in the report. Chairperson, and I will propose that. Well, she's indicating that we go through the statement.
Okay.
But the issue is very important that let's go through the statement so that, because we are doing this, as I said, for the members of the public to understand what I received, and especially the fact that I'm targeting individuals. And I indicated to you that somebody was even asking me, are you fighting the president? So that people can know that within my responsibilities, this is what complaint we've received. This is where the facts, I mean, everyone saw it, but then some people might not have seen it and they are listening. They just want to understand what happened. Thank you.
Yes, no, that's fine. I think then let's do it like this, because it looks like my effort to try and save time is not successful. You go through the statement and let's do the other way around. When I want to interrupt you to clarify something, then I'll do so. So all right, then let's go from 251.1.
Yes.
Because yes, indeed, the people at home don't have the statement. The members do have, and let's rather than have it from your side. I was just trying to speed it up here. Okay, let's start at 251.1 public protector, because
yes, on the 18th of October 2017, according to the complaint, was that an amount of 500,000 was paid into the EFG2 Trust Foundation account by a certain Mr. Venter, Petros Venter, on the 18th of October 2017, on the instruction of the late Mr. Gavin Watson. So the 500,000 was part of the 3 million, which had been transferred from Mr. Watson's personal account by a Natasha Olivier, the PA to Mr. Watson, into the account of Mioto Trading, which was the company of Mr. Venter's sister, Miss Margaret Longworth. So that was the complaint. And then that the money was paid from a personal account of the late Mr. Watson, the CEO of, he was the CEO of Busasiwe. So then the money was transferred to the account of Mioto and the company which was closely associated to Busasiwe. So that was the complaint, and that was said to be the money paid into EFG too. So as we've explained, I think I'll also try to just pick up important issues. Then on the 6th of November 2018, paragraph 2.5.1, 251.4, during a questions and answer session, indeed, Mr. Maimane presented some documents to the president that there is a proof of payment and a sworn statement alleging that there's money paid to Mr. Andile Ramaphosa. So the president confirmed that he was aware of the payment, but had been satisfied that it was a lawful payment of services rendered by a consultancy firm owned or operated by his son, Andile Ramaphosa. So it later transpired that the president's answer to the parliamentary question, or to that question, was false. So on the 16th of November 2018, the president sent a letter to the Speaker of the National Assembly purporting to correct the answer he had given in the National Assembly on the 6th of November 2018. In the letter, the president confessed that the payment was actually a donation towards his campaign to be elected as president in 2017, December 2017. In his complaint, Mr. Maimane alluded that he was concerned that there was a possibly an improper relationship between the president and his family on the one side and the company African Global Operations on the other side. So to confirm what you said earlier, that he is the one who raised this issue of December 2017 in the letter to the speaker. So that's what it was captured, or the evidence which we then also considered.
Good. Thank you very much, Project. Okay, let's then just, okay, well, we don't have to deal with that segment because I already asked you questions.
Then a second, okay.
Yeah, you can carry on.
Yes, in fact, maybe before then the issue of my determination was whether the payment of the said amount as a donation of to the campaign was proper, and whether it did not amount to money laundering due to the money having had to pass through several intermediaries. And this was actually exactly what Mr. Maimane said in his letter of complaint, not to say it was from what we have uncovered as the public protector, because that's not our mandate. And then another complaint was received from Mr. Floyd Shubavambu, the deputy president of the EFF, And his complaint was premised on section 4, subsection 1 of the Executive Members Ethics Act. I think we were supposed to say Executive Members Ethics Act, in respect of the alleged breach of the Executive Ethics Code by the President in appearing before the National Assembly on the 6th of November, when he was responding to this particular question about the 500,000 donation. So that's what we did. So as this was a separate complaint, normally within the office, if the complaint is similar or it relates to the same facts, then we merged this complaint to the one which was lodged by Mr. Mkhwebane of the DA.
Thank you very much. And sorry, just for the sake of completion, can you, you jumped to 53. Can you just read to 53? Because I think that's what gives context as to why this particular company, I mean, if a particular company had given money to the president's son, so what? So the issue is why did Mr. Mkhwebane identify this particular company for any suspicion? 253.
So Mr. Mkhwebane in his complaint further alleged that Busasa was widely reported to have received billions of rands in state tenders. He further stated that he was concerned that the president may have misled the National Assembly in his reply to the question on the 6th of November 2018, and that the true facts of the matter needed to be established.
Right. Okay. All right. Thank you. So at least as far as Mr. Mkhwebane's complaint was concerned, it had two legs. One was the credentials or lack thereof of the company itself. And secondly, the question of misleading of Parliament. Okay, good.
Correct.
Right. And Mr. Shivambu's complaint, you've already paraphrased here. All right. Okay, now the issue of the benefit, the alleged benefit to the president or deputy president, and I'll be saying the president, but I think everyone knows that at the material time, he was the deputy president. For the purposes of Section 96, it doesn't matter. He was a member of the cabinet.
Correct.
Okay. Now, can you take the committee through the issue of the benefit? Just explain why if it's a personal benefit, then it attracts the disclosure under the code.
Okay, I think that is in paragraph 259. So during my investigation, I received evidence that showed, among other things, that there were monies transferred to the Cyril Ramaphosa Foundation, that Mr. Watson was present at the fundraising dinner hosted by Mr. Ramaphosa, and that on the 17th of November 2017, Ms. Donay Alain Nicole, the president's legal advisor, sent an email to the president regarding fundraising and events. So this is the email which Donay sent to Mr. Ramaphosa. Hi, please find questions, notes around fundraising events. I've tasked PG to raise about 15 million. He has gone Johnny Coplin on board and is meeting a few other people. He's suggesting an event with 15 to 20 people on the 24th after the NEC. Is this possible? I think we should still schedule the following: cocktail with black business, maybe 30, including more sake and other, sake others. Cocktail with the Greeks suggested by Theo. You said yes. You have said yes, just trying to prioritize and get into your diary. People I need you to call, please, Mick Davis to coordinate.
Sorry, can you pause there?
Yeah.
Just go back a little bit. Yeah. Okay. Before we get to the next section, which of the email.
Mm.
I just want to put a few questions to you. One, just for context, so that everyone knows what we're talking about. This, who wrote this email,
It was Miss Nicole
and
Done.
who was it addressed to?
It was addressed to President Ramaphosa.
Right. Okay, so when it says, for example, you have said yes, the you, it would be Mr. Ramaphosa.
Yes, it was.
And where she
directed-
says, I think we should do this, then that's her making whatever suggestion. Yeah.
Yes.
Okay, I just wanted that for context. Then it says, this next sentence is important in relation to the next sentence. People I need you to call, in other words, people that Miss Nicole wants Mr. or rather President Ramaphosa to call, and then, okay, you can carry on.
Yes, they are this Mick Davis to coordinate a group from London, including Martin Moshal, ask for a collective of 20 million. Eric Sampson to thank him for the money and ask for another 10 million. Can I ask the following for money?
Chair.
Tony,
Joseph Boss, Public Protector, Advocate
We-
Bauer.
We had been very careful about not showing people's names and phone numbers. Up to now, and there
okay.
seem to be
Yeah.
phone numbers on
Yeah.
the,
Okay, no, fine. I think we can block the phone number, but the names we are there. They're there.
and there's an account number that comes up in the.
Yeah, no, fair enough. Okay, we'll watch that, Chair. Okay, just move, you know what, move the thing to Eric Sampson. In other words, the number one that don't show on the screen. Yes, they started number two. Okay, carry on.
Eric Sampson to
Hmm.
thank him for money and ask for another 10 million. Can I ask the following for money? Tony,
Georgiadis, I think.
yes, Georgiadis, Kojo Mills, David Ngobeni, Paul Icon, request for meetings, Paul Icon, Steve Ratau, Paul Kuna, Mane Dipicho. So
Right,
this were the this was the evidence which we collated during the investigation.
all right. Now, okay, let's stop there. Because when we deal with what I call the base documents, this becomes a central theme, and Chair, again, for the sake of progress, well, we want, but we also can't show all the emails and all that. I think the role of the emails, if we show one or two, what we're really after is what role did the emails play rather than the contents per se. But so that's the first reason. The second reason is that even if we had all the emails, we can't show them because they are sealed somewhere in Gauteng. So these ones we can show because they come from the pleadings, not from the sealed documents. Yeah. Okay, fine. All right. Can we then go back to paragraph 258 so that we deal with what I'm going to call the base documents, which we are going to use in your testimony. 258.
Maybe SC before 258, or I thought you were still following up.
Okay.
So I think this also was showing that during the investigation and the fact that the interviewing of, we're still going to deal with those. We did interview Nicole Udone, we interviewed Mutlatsi, we interviewed Chauke, we interviewed the president, and I think Mr. Fenter, yes, but I just want to deal with the issue of the involvement of the president in the process. because those were some of the issues which, when we go through, you'll see why we are saying he was aware, because they were saying, no, we only invited him to the cocktails. Actually, even in the letter responding to the speaker, in fact, responding to us, was saying, no, I was not involved. I didn't know anything.
No, we'll get to
So
that.
yes, that is what we've captured
Okay,
in the pleadings. Yeah.
thank you, thank you. No, we'll get to that and we'll analyze what, as I said, really what we're after is your reasoning.
Why?
And
Yes.
yes, and why you came to certain conclusions, whether it was for all the nefarious reasons that are alleged in the charge, or that it was not. Yeah. Okay, so I wanted us to just, before we do that, because that information emanates from what I call the base documents, for lack of a better word. So can we first tell the committee what those base documents are at 258?
So it has already been established, and I hereby confirm that the key documents which will be used in my evidence to rebut the allegations into the charges which emanate from this Busasa report are the CR17 Busasa investigation report, the pleadings in the Constitutional Court appeal, especially my founding affidavit, the Constitutional Court judgment, especially the minority judgment of Chief Justice Mkhwebane, various newspaper reports which detailed information regarding donors and recipients of CR funds. And I think this is because the information which we also had in our possession. The recordings of interviews with some of the key players, and the recent SABC interview making reference to foreign funding to influence the 2017 ANC conference outcome in favor of President Ramaphosa.
Right. Okay. Now, with the exception of the last item, because we've already said that anything that happened post the report is really merely for context. Those other 5 source documents are before the committee, and I'm not sure if Temgosi finally managed to open the recordings. I know there was some technical problem, but anyway, putting technical problems aside, all those documents are before the committee.
Yes.
Okay.
Go ahead.
Thank you. And the recording won't show that part.
Okay, yes, correct.
Thank you. No, sorry, I was signaling to Temgus. All right. Thank you. Okay, now let's then come to the evidence you are leading. Whether you are dealing with the High Court judgment or the Concord judgment, for the purposes of what I'm going to ask you, it doesn't really matter, because both of them made the same finding. Concord confirmed the High Court, correct?
That's correct.
Right. Now, without getting into the detail of the specific emails, it seems that the president's version and that of his CR17 managers was that the president basically did not know about the activities of the CR17 campaign. He was intentionally insulated, what in business we call Chinese walls. A Chinese wall had been built between him and the CR17 so that he didn't know what's happening on the other side of the wall. Can you just paraphrase, maybe in your own words, what the version was from your interviews with the people that you have just mentioned?
Yes, the interviews which were conducted, as I said earlier, we interviewed Donay, Mutlatsi, Chauke, and they were saying that they were the campaign team, because that's what, when we wrote to the president, we met with the president. Indeed, he confirmed that he didn't know anything about that. He was told, we will be running this process for you, but then you are not going to, in fact, we are not going to tell you anything, but then we will invite you, or he was invited, or people were invited to attend dinners and events for the fund or the fundraising event. So that's what, or that's the information which we were given when we interviewed those collective.
Right.
So it's there in the report, and I know you might take us there as well, or members of the committee.
Okay. Now, all right. No, we can go there. All right. Now, this, if you can still remember, how many times did you have to interview the president?
We met twice. The first one was when the letter of we normally call it, in fact, the first letter where we informed him about the investigation. We also requested all the evidence which he is having about this matter. So after the letter was drafted, it was then delivered to the president to make sure that the process is, or the investigation is conducted in such a way that there is no leakage or compromising the investigation.
Right. Okay, I think the part you wanted to refer the committee to in the report, you'll be found at 5.1.10.9.7.
Yes, it's the main paragraph is 5.3.10 of
Yes.
the report.
Yes. Can we start at, oh, sorry, it's bundle E, item 10 point, number 1. That's the Busasa report.
Winnie, slow tipper. Page number,
Oh, of the typed page of the
page 41. Is
40,
that 43?
3, actually, 43.
Okay, thank you.
Whilst she's looking, because in the report, the first meeting was on the 29th of January, 2019. Yes.
Okay. The first meeting with the president was?
29 January 2019. It's in paragraph 5.3.4 of the report, where it says issues in dispute. Yes, paragraph 64.
Yeah. All right. Okay, I wanted us to start at 5.1.10.9.7 so that we don't lose the point you made earlier about what I call, quote unquote, the Chinese wall. Can you read that into the record?
Okay, so it's 5.1.
10.9.7.
I know we 0.1.10. Okay.
You also have it on the screen. In
That's
case
with according to.
Chairperson, I must look for my second eyes.
Okay.
Yes, that's
All
why I
right.
prefer to read
Oh,
here.
it's fine. Okay.
Yeah.
We'll wait for you.
Okay. Okay, it says, according to President Ramaphosa, a deliberate decision had been taken by himself and by those leading the campaign that he would not be involved in fundraising, even as he would address meetings and have a few dinners with potential funders. These meetings and dinners were with potential funders were used as occasions where he would have outlined his vision for the ANC and the country.
Yes, okay. Now, this, you would agree, this is what is at the core of the CR17 issue, correct?
That's correct.
Yes. Let's put aside now the issue of misleading Parliament and what have you.
Mm.
But as far as the CR17 issue, this was what I call the version, which was the president's version and that of the CR17 managers. I think that's what they're called.
Correct.
Right, okay. And so that's what we're going to be interrogating.
Mm.
And we need to, again, keeping the eye on the ball, that we are following your logic as the public protector rather than anything else.
Mm.
Now, this version, in your finding, were you able to accept this version or this defense, quote unquote, of, you know, there was this lack of transparency, or did you reject it? If you did, then we'll go to the specifics.
This version was unacceptable because I've shown, or the emails I've read earlier,
Mhm.
because there would be a lot of other information which proved that the president was involved or he was aware about those donors and funders.
Mm. All right.
And to stress again that by then he was the deputy president. And that's what we were investigating and what Executive Members Ethics Act says about members of cabinet and as well members of parliament.
Yes.
About declaring any donations.
Right. Okay. So again, I don't want to belabor this point, but just so that there's no debate in anybody's mind, on the president's own version, because we must not portray as if the president, like said, no, I don't know what dinners are you talking about there. So on his own version, he had attended and addressed these dinners of donors, correct?
That's correct.
And more importantly, on his own version, at these dinners, two things were discussed, broadly speaking. His vision for the ANC and his vision for the country.
Correct.
Okay, all right, fine. We'll then come back to that here. All right, then you can take us to the paragraph that you wanted to highlight on the same vein. It was 5.3.
Okay, it was then the statements or the interviews we conducted with the campaigns managers. Yes, so it's from 5.3
Yes,
of
good.
the report.
Good. And if I understand it correctly, the first interview you had was with the president, and in the spirit of Mail and Guardian, it says in the report he allowed you. I don't think you needed this permission, but I think for the sake of politeness, he then allowed you or led you to speak to the campaign managers.
Yes.
Right. Okay, I think then that is clear. All right. Now, let's then go to that issue. We will come. We'll come to the issue of the what to call it, the code. You remember there's that issue about using the wrong code and all that, yeah. But so we're not there yet, yeah. Now, can you maybe in your own words explain to the committee why you then rejected the version? I mean, the president could have gone to those dinners and maybe he didn't even know what was being, that after he has left, these people are going to be asked for money. But what evidence did you have to refute the version of the president and the so-called CR17 managers?
Maybe let me say, Chairperson, that when we check what happened, what should have happened, and the discrepancy between what happened and what should have happened, and investigating with an open mind. Firstly, the letter which was written to the president, because I think the South Africa and the world were thinking, okay, this money was for the son. But secondly, when the president wrote to the speaker correcting, he said the money was for his campaign. And it was, okay, the 500,000, which was then paid. So when the letter was written to the president, the meeting was held with him. Indeed, we engaged, we brought the complaint before him, and that, okay, he even said, I was not involved, my campaigns team managers were involved. Hence, following the Mail and Guardian advice or case, then it was for the investigators or the engagements between me and the investigator, Mr. Mataboge. Okay, we need to subpoena all the campaigns managers. We need to subpoena Mr. Fenter, because there was an affidavit going around of Mr. Fenter. We need to subpoena the PA to Mr. Watson. We need to subpoena Mr. Watson. We need to subpoena the bank statements. We need to subpoena every document which will assist us in this particular aspect. So it's not just a question of saying, Mr. President, you are saying, okay, you are not part of the process. Okay, thank you. That's it. So we had to, because we have an inquiring mind, we cannot just receive information. I think there's a paragraph in Mail and Guardian which is still going to take us through. And for the public to understand that if you have an inquiring mind and you are an investigator, and that's what we do as the public protector, we're not just receiving a complaint, go to the department or to an individual and say, there are these allegations, you respond, okay, we close the matter. Being a public protector and investigating, you must go to the root and to the truth. And it's not only the information which we listen, like what the newspaper is saying, and we take it as gospel truth. We need to go beyond or behind the information. So there's a difference between information and evidence. And most of the time, we rely on the evidence. Information, we use it as a lead. In other words, if something is published and there's this thing which was before Parliament, and the president has written this and is telling us, this is what I said, then we'll have to go deeper and find out. So I think I wanted to give that context before I just say, yes, I didn't believe it, because it will be as if I went into the investigation with a closed mind. But then we had to go and interview all these people, and the recordings are there, the transcripts are there, where you will see, and the report is very clear, why we didn't take this information and why didn't we take his version, because it was not only the first time where we met. The investigation, we investigated, we had to go through every documentation and then prepare what we call a Section 7(9) notice, where we are saying, you are implicated, these matters are substantiated. Your version originally when you responded, we are not considering it. But then here's the evidence which we have. Can you rebut this?
Yes, no, thank you. I think that's very helpful. That's exactly what I think we're trying to do, to say, it's not like we're saying you just woke up with some conclusion. We want to trace the journey from the complaint to the findings and to the remedial action. And what happens in between is how you got there, which is really what you're charged for. Nobody, I don't think the committee sees it as his job to say this conclusion is questionable as a conclusion, but its job is to find, and the court's job, by the way, is to find how did you get there. Whether the conclusion is right or wrong is not. That's what we lawyers call the difference between an appeal and the review. An appeal is to check whether the outcome is correct. But in a review, that's not what the court is interested in. It doesn't care whether it's correct or not. It's interested in the journey. How did you get there? Did you break the law, quote unquote, in reaching that wrong conclusion or incorrect conclusion? All right. Now, okay, fine. So am I correct then, for the benefit of the members, that in what I've now called the journey, there were 3 signposts. First one was the president, because after all, that's the person who's accused, correct? Or who's complained against. Sorry, maybe
yeah,
accused
let's say
is
that,
a strong word.
yeah, because
the complaint is against. Yeah, okay.
We're not a criminal court. Yeah.
Then the second signpost is you speak to him as the person, and then he says, it's like someone accuses me, then I say, or complains against me, then I say, no, it was not me, it was my juniors. Then you have to go to them, right? And then the second, in the spirit of male and guardian, of following the truth, so to speak. Then the second signpost is the emails. Then that led you to the emails. So those were the 3 signposts, if you like, of how you then reached your conclusion. Correct?
Yes. Remember, which I need to put it into context, is that when the investigation is ongoing, writing letters, person responding, interviewing everyone, subpoenaing bank statements, subpoenaing any other information, and that
Section
inquiring
779.
mind, yes. So the Section 79 notice as well, it's still during investigation.
Right.
So at that particular time, you're still receiving information. So, and that's when you find that there would be evidence which you will get. We're coming to the other reports, which we'll have to deal with. We're at the stage where you need to decide, is this critical information to utilize? But since it's critical, you might as well include it so that when the matter is reviewed, they can also see that this is the information you've gone through in the process. So that's all the evidence which we consider.
Good.
True.
Thank you. Yes. And I think that accords with what I think Ms. Power put to Ms. Mkhwebane, if I'm not mistaken, in the context of the rogue unit report, that if some critical information comes up even 2 days before you release your report, you would then have either to reconsider. You can't just say, well, I'm not going to look into this, even though it's critical, as long as the report has not yet been released. Correct?
As long as, definitely, because it's still part of the investigation up until the end of the investigation. Yes, if the information is so critical that you didn't even reference it, or you would want to hear what the other side is saying, definitely sometimes we will issue supplementary Section 79, or as well call a meeting and say, there's something like this, can you clarify? Because that is still part of the investigation. Yeah.
Good. All right. Good. Okay. I think now that that is clear, then let's then go through the all those stages.
Mm.
Now, the majority judgment in the unanimous judgment in the High Court and the majority judgment in the Constitutional Court reviewed and set aside your report, correct?
That's correct.
Right. And just so that, again, there's no confusion, you don't, this is not an appeal court where we are. So
Correct.
we're not here to say, no, this is what it's not like a higher court, quote unquote, or forum than the Constitutional Court. So we accept that the judgment is the judgment.
We accept, yes.
Yes. But that's not what this committee is all about. This committee is about checking your state of mind as to how you arrived at your conclusions, for better or for worse. But that's what we're, quote unquote, inquiring into. Right. Okay. So let's walk.
Maybe
through-
let me clarify this.
Yes.
While still at it, I know we'll come to that.
Mhm.
The issue of, yes, the judgment of the High Court and the judgment of the Constitutional Court. Based on what it has been said. And indeed, this committee won't review that. But the fact of the matter is, if it's based on wrong facts, and if it's based on information which I don't agree with, indeed, I will indicate that that's
Yeah.
not the case. This is what was in my mind or in our mind when we were investigating this particular information. So just to prove that the issue of intentionally or grossly in a negligent manner, I conducted the investigations. Yes.
Absolutely. Thank you. No, I think that in that exchange we had with the chair and Ms. Power, that's really where the nub of the issue is. As we said, the drafters of the rules of Parliament, in their wisdom, decided, for example, that negligence, ordinary negligence, which we call culpa, is not enough. So even if it could be found in a particular case that you were negligent in this sense, in the legal sense, that you can't be impeached for that. The drafters of the rules decided in their wisdom that they must put that adjective, that it must be grossly negligent for it to constitute an impeachable offense, and that for reasons that Ms. Power and I will debate when we do the closing remarks. But I think, yeah, that's an important point. Right. Now, with all these pools and people and interviews and sections of 29 and out the alteram partem and this meeting, this first meeting with the president, the second meeting with the president, and all that. We then come to, you made certain findings, correct?
That is correct. Actually, the findings were in the section 7.9 notice.
Right. The provisional findings, let's
The
call them
provisional
that.
findings.
The provisional findings, yes. Okay. And those provisional findings then typically then will be given, if I'm the person complained against, you give them to me so that I can criticize them and say, no, you shouldn't make those adverse findings to be final, and then you assess that.
Yes, I think during this investigation, what transpired is that as I said, again,
Mm.
the chief investigator was the one who was investigating this matter.
Mhm.
The chief investigator was then in constant communication with me on the evidence, the information they are collating,
Mhm.
how to deal with certain information and evidence, how to analyze. So then when the final drafting and analysis of information, which is done by this investigator, and then being drafted, and then I was receiving drafts on this particular matter, and that's where the issue of, okay, possibly here you can improve, here you can add more information, here you can go further and interview the following people. So it's that process. It's not a question of just receiving the information and the responses, drafting, and then boom, it ends there. So it's work in progress, which goes through various stages. And when that is also served, the Section 7(9) notice, the recording which we have here, that's where the president was taken through that, the Section 7(9). It was not just a question. Sometimes we just send it to implicated parties. But in this particular instance, because of the level of the president,
Mhm.
and because of the closely guarded investigation, where when the Section 7(9) notice was drafted and completed, the acting chief investigator, the chief operations officer, Ms. Baloyi, was then also invited in my boardroom, where I took her through the report, the draft, in fact, that Section 7(9). And I said, you will also accompany us to meet the president, but this is the document which we came out with. The fact of the matter is that I didn't want it to go through all the stages of, now it's a submission, this one is receiving it, now this one can copy it, can do this. I think it was purely for securing the integrity of the investigation, but to protect as well the person we are investigating, to protect any person which we got the information from. So yeah, that's what happened in the investigation.
Thank you, Advocate Mkhwebane, Public Protector. We will pause there for
Thanks, Chair.
10 minutes and take a tea break.
Thanks, Chair.
Thank you.
Recording stopped.
We're back from tea. Advocate Mpofu, over to you.
Thank you, Chair. Advocate Mkhwebane, I just wanted to just to clarify one detail, which so that we don't leave anybody behind. Remember earlier we spoke about the Mr. Maimane's question, the president's answer and the correction and all that.
Correct.
Now, yes. Now, at the center of this, which I did not clarify, I think for those people who are not familiar with the details, was this 500,000 rand payment. And it was made to an entity called EFG2 account, correct?
Correct.
Right. And so the correction was not that the 500,000 has not been paid, or the correction was that the 500,000 has been paid to EFG2, which is an account of the CR17 campaign, correct?
Oh, it's correct. In fact, EFG2 is, it was a trust account of a firm of attorneys, which
Right.
they requested to collect all the donations.
Yes, you're right. So yes, it was the vehicle, let's call it, the vehicle that was used to collect the money.
Correct.
Okay. So in simple terms, forget EFG, ABC, whatever. In simple terms, what had happened is that Busasa, Mr. Watson's company, had paid money into the account or the vehicle that was used for CR17, which is the campaign of the president.
Correct.
Fine. Okay, good. Wanted us just to get that out of the way, which is because, and to simplify it. Yeah. All right. Now, we broke for the tea at the stage where we had established that you had in following the complaint, you had discussed with the president then as part of his version said, no, the people who know about this are so and so and so and so. And then you spoke to those people. So I wanted us then to go to those interviews, those, let's call them follow-up interviews that you then had with those people.
Yes,
And
it's page 64 of the report.
yes, starts at
Maybe let me clarify that Mr. Fenter's affidavit, which again, what was disputed by the president was that he said the money was paid into Mr. Andile Ramaphosa's account. That's when the president corrected it, that it's not Andile's account. So I think then it shows the journey of then investigations, because we didn't just take what the complainant was saying, because this is what the complainant said. But during the investigation, then we uncovered all the other facts. Yes.
No, good enough. Good enough. Yeah. Again, in the spirit of simplifying this thing, Mr. Fenter's affidavit and Mr. Maimane's initial version, quote unquote, was that the money had gone into the son's business account.
Correct.
The president corrected to say, no, the money went into the father's campaign account.
Correct.
Right. Okay, good. Now, we then go to 64, page 64. That's where you summarize, if you can then summarize without necessarily reading it word for word, what the president told you when
Okay.
you, in your meeting, in your first
Meeting.
meeting.
So I think just to also clarify for the benefit of committee members and the public when they read our report, because when we deal with an issue, like when we receive a complaint, we then assess that particular complaint, which is also done by the assessment committee. And then when it's allocated to an investigator in this instance, because of the sensitivity, I said, then the chief investigator should investigate this matter.
Right.
Then when we receive the complaint, we then collate information. We then, and in our service standards, which we're still going to go through sometime, we then say, we should meet with the complainant to understand the complaint. In this instance, it was an issue of clarifying, because what the DA leader, Mr. Maimane, then said, this is the complaint which we've attached in the report. And the complaint deals with this allegation answering and the fact that the monies have been moving from here to here. Possibly there might be issues of money laundering. Then Mr. Shivambu lodged a complaint and was specific to say, look into this matter also in terms of the executive members ethics code. The issue of misleading parliament, the issue of exposing yourself to a conflict, risk of a conflict. Then under this issue, which I will take the committee members through 5.3, is whether there is an improper relationship between President Ramaphosa and his family on the one side and the company called African Global Operations on the other side. Due to the nature of the 500,000 payment passing through several intermediaries, instead of going straight to being donated to the CR17 campaign and raising suspicion of money laundering. So there were then common cause issues. Normally we would say common cause issues is, well, that's what you were doing with Advocate Power. These are issues which are not in dispute. These are issues which are out there that indeed everyone agrees that this was the 500,000 was paid into EFG2 Trust Foundation by this Mr. Fenta, and this Mr. Fenta was using Miyoto trading, and this Miyoto trading is an account which belonged to Mr. Fenta's account. So this Mr. Fenta was playing the role of being a bookkeeper and stuff like that for the company. So the issues in dispute where we're going is then where the president, in my meeting with him on the 29th of January 2019, I raised this issue of a 500,000 payment into EFG2 account because according to Mr. Fenta, it belonged to the president's son. So the president then indicated that he was not involved in the fundraising process. Hence, he also took us through the letter he corrected to the speaker. Then he said that he only got to learn about the alleged payment from one of his advisors, Mr. Pejani Chauke, on the 5th of September 2018, where Mr. Chauke informed him about the rumors that his son Andile had received a 500,000 from Busasa or AGO. So that's when then the president advised that actually he was not involved and that the information pertaining to the fundraising of the CR17 campaign can be sourced from the names of his campaign managers. So having regard to the broader allegations, that's when we then had to meet with all the parties involved. So 5.3.9 of the report, that's where we met with the directors of Edelstein, Faber and Krobler, EFG attorneys, who were responsible for the disbursements of the funds in the CR17. And then we also met then with the president, Nicole, Mutlatsi and Pejani. And then we also met with Andile Ramaphosa. Actually, Mr. Ramaphosa and others, we request Andile Ramaphosa, we then subpoenaed their affidavit.
Oh.
And then we submitted bank statements from FNB and ABSA. And then we also interviewed Mr. Fenta, Mr. Gavin Watson, Miss Natasha, the PA to Mr. Watson.
Good.
So then that's the evidence of Mr. Mutlatsi on 5.3.10.1.
Perfect. Thank you. Okay. Thank you. I think that the picture is clear, but again, I think we need to be patient so that those who are not here can follow some of the things that you and I might take for granted. So this acronym EFG, which is the account into which the money was paid, as indicated at 5.3.9, was actually an acronym, not acronym, abbreviation, was an abbreviation of the firm of attorneys that was involved in this.
Correct.
That was where the trust account was housed.
That's correct.
And those attorneys, Chair, the full name is reflected at 5.3.9, which we just saw now. It's attorneys Edelstein, Faber, and Grobler.
Yes, correct.
EFG. Okay,
Yes.
good.
And actually then I interviewed the late Mr. Faber, but
Good.
who came with the other, I think Mr. Grobler.
Yes. He was one of the people that you interviewed, the attorney. Okay, good. All right. Now, then let's go back to where you were. Or before we do that, just another important mental picture. You know, all these things, it's not as if they all happened like this week and then the other one happened the next week and so on. And I think it's important again to show the timelines. So according to the information here, it's correct that this payment into the EFG account was done in October 2017. Okay, I'll help you.
We'll have to go to that,
Yes.
yes, so that I can be sure
Yes,
of the
yes,
date.
okay.
Yeah.
But in the report, you'll find.
Yes, it's true.
Paragraph 251.1 of the affidavit.
251.1, yes. Okay. Thank
In the report, because it's updates 5.3.10.4. Yes, that's correct.
Okay, I think I'd rather take Advocate Bowers one without the 0.10.3.5.
Yeah.
All right, no, that's fine.
Sepo is having it already.
All right. All right. You said 253.
251.1. I don't think it's an issue that it's 18th October 2017.
Correct. Yes, thank you. Yes, that's the one. Just okay, just to situate it. Yeah. So 18 October 2017, that will be on page 610, 251.1. That's when the amount was paid into the EFG2 trust account, correct?
That's correct.
Okay, that's 2 months before the December conference in Nazareth of the ANC, right?
Yes, November. Yes, correct.
Okay, okay. So then the conference happens, whatever the money is used, and then Mr. Maimane raises this question a year later. I think it's November 2018. Okay, so we'll
Yes.
assume Mr. Maimane had his own interactions with Mr. Fenta or whatever, but he raises the alarm, so to speak. Sorry. Yeah, if you go to the report, he raised it on the 6th of November, 2018, a year and a month later.
Correct.
Okay, good. The president answers, he corrects it a couple of weeks later, and so on and so on. And you meet with and then there's a complaint by the complainants. We've gone through all that. And then you meet with the president in January 2019.
Correct.
Okay, okay, then the rest we will deal with. But just for people to have a mental picture of the sequence of events. Yeah. Right. So we were at 5.3. You then meet with the
Mr.
campaign
James.
managers. Yeah.
Yes. That's
All right. You can take the committee then through briefly what they said to you, or that what emanated from those meetings.
okay. What we did was that let them subpoena the affidavit of all the campaigns managers
Mhm.
to submit their sworn statements prior to the interview. Indeed, we met with Mr. Mutlatsi, who indicated that he was one of the members of the fundraising committee, himself, Bejani, and Done. And then according to him, he said they decided early in 2017 to approach donors for the CR17 campaign with the clear condition that the donors should not expect any favors in return for their contributions to the CR17 campaign. So then there was a conscious decision by the committee members, as well as an agreement with the president that he should not know the identities of the donors or the amounts they've pledged, which all three of them were saying so. So Mr. Mutlatsi said he's the one who approached Mr. Gavin Watson, who he worked with, or they were together in fact, he knew him for more than 20 years. And he's one of the people he identified that he should be approached for this donation of 500,000. So in fact, he met with Mr. Watson, and Mr. Watson offered this 500,000. So that's October, indeed, 2017. So that the decision was taken by them not to do anything in writing, because we were saying, where are the minutes to prove that this was a project? They had no records or documentation for such a project plan. There were no minutes of the meetings which were kept for this project. So according to him, Mr. Bejani was the overall leader of this campaign, and Done Nicole was the facilitator. So Mr. Mutlatsi, because we also asked them, then he said, we asked him, how do you know the president? He said, no, they were together in the National Union of Mine Workers days. So they knew each other since then. And all of them, we asked, how much did they pay? Actually, before that, then we also asked the president, was the president present at those dinners, which had been organized by the campaign managers for donors? They said yes, and he would address them, and he would naturally meet and greet the benefactors. So then we asked him how much was donated, or the total amount. He was saying is around 200 million.
Who's that?
Mutlatsi. Then Bejani, we also met him. We then, he also submitted a sworn statement. And indeed, he confirmed that he's the one who alerted the president about the rumor that the 500,000 was paid into Andile Ramaphosa's account. And he corrected that, especially what the president answered in parliament. Then he indeed confirmed that he together with the Mutlatsi and Done were part of the campaign managers. They will coordinate and they will assist various branches with monies which they collated. So Mr. Bejani then also indicated that they didn't record the activities of this campaign. And then and I indicated in the report as well that he was not helpful, especially as the leader of this, because he was not forthcoming with information. And then we also interviewed Done, and who was the one who facilitated the initial meetings with the EFG too. So according to her avid, she took us through the donation which was acquired from Mr. Gavin Watson.
Mm.
So I think here you'll see as well, for now, we were focusing on this 500,000. Which was donated towards the CR17 campaign. So she also then confirmed that there was this fundraising dinners, and that she also alerted the president about the inaccuracy of his response in parliament. Hence, they corrected that information. So we asked her, how do you know the president? She also confirmed that they were together, or she worked for some time at Shanduka. And then she also indicated that it was agreed that the identity of the donors and the amounts pledged should not be revealed to the president. And further that she also confirmed that it was around 200 million, which was collected from the campaign. And they also agreed that this is what was going to happen. So we then mentioned in paragraph 5.3.10.26, I think you can note that paragraph after we deal with all the people we have interviewed, because this is the information which we are bringing in, that according to the emails, invitations and instructions, it confirms that the president was constantly informed of the activities of the campaign by the campaign managers, where upon his advice and approval on specific matters would from time to time be sought. So this will then, when we deal with the emails again, it will show why we commented like this. So then Mr. Andile Ramaphosa, then we were asking about this, his relationship with this AGO, and confirming this mandate which he had, or the contract he had with Bosasa. And then they had an advisory mandate and anti-bribery and corruption policy signed between Blue Crane, his company, and AGO in December 2017. So Mr. Shivambu's complaint was specifically focusing on Mr. Andile Ramaphosa's company, and how the president responded. Hence, I'm saying that was the focus of our investigation. And in the report, we've attached that agreement so that it can be clear that that matter was investigated on, and it was the evidence which we've collated as far as this matter is concerned.
Okay, can we, okay, the people who are not, shall we call them the main players, I don't want us to spend too much time on them. So Mr. What's his name? Andile Ramaphosa, you had an interview with him and it's summarized there, correct?
We didn't, we couldn't get hold of him, but
Affidavit.
at least he finally submitted his one statement here.
Correct. Mr. Watson, the late Mr. Watson, you had an interview with him, correct?
We did indeed interview Mr. Watson, and the recording as well was shared with the committee, and he indeed confirmed that Mutlatse approached him and he donated to CR17, and as well he was asked about donating to the NTZ individual, the campaign of NTZ, which he confirmed at the stage when we were interviewing him.
And just to fast forward,
and he said he attended the dinner not all the dinner functions, but he did attend the dinner, and indeed, Mr. President Ramaphosa was present at the dinner which he attended.
Yes. Okay. So at least we know that at least in one of the dinners, he was there in the presence of the president.
Yes.
Yeah. The other issue which I wanted to deal with, just in passing, since you've mentioned it, is that there's an allegation or a proposal a proposal that he should be charged in terms of Section 11 of the Public Protector Act. And that had to do with this NDZ issue you're talking about.
Correct.
Under oath at one time, he said he had donated, and then under oath at another time, he said he didn't.
Yes, because remember under Section 7, subsection 9, there's where it says the implicated parties might request to interview or request further clarity from the people we've interviewed. And then I allowed the president to, or I actually at the discretion of the public protector on how you will be doing that. So then I requested the attorneys of Mr. Gavin Watson to contact their clients. And we then said the president should send the questions they would want clarity on. Indeed, we sent it to the attorneys of Mr. Watson. That's when he submitted an affidavit again, answering those questions, but now saying no, he never donated to the NTZ campaign.
Right. And again, I know that South Africans know these things, but this is an inquiry. Somebody 100 years later might be reading this and not know what's NDZ. So that was a reference to the other campaign of Dr. Nkosazana Dlamini Zuma, the NDZ her initials, correct?
That is correct. And again, that shows you the criticalness of saying information under oath, and then again coming back and retracting that information. So hence that case was opened.
Yes.
And the importance of an affidavit which he originally submitted, contradicting the affidavit which now he's responding to the president.
Yes, okay. Well, okay, let's not go there for now. But for the sake of completion, we now know that Mr. Watson passed away. So then again, you had an interview with Ms. Olifir that you mentioned earlier, correct?
That's correct. That's the PA to the late Mr. Watson.
And then, of course, as you've already said, you had an interview with Mr. Faber, Perry Faber, who was part of the EFG connection.
That's correct. And he is the one who told me that he was approached by Ms. Done to open a trust account dedicated to the campaign, which he did in compliance with the legal requirements, because we had to find out, how did you do that? Were you compliant as well, being yourselves? And did you send were you audited by the Law Society, which they say, they confirmed that they followed all the processes.
Right. Okay, good. Okay, fine. So that's the landscape. Now, this is a point that I had come to earlier, and you'll see that I'm eager to get there so that we can start evaluating the logic in your report here. So to preface that, am I correct then that what you then had was what we call the version? So the version of all these people, the managers, the president, no, there was a deliberate plan that he must not know, and so on and so on. So let's call that the version. And then you subsequently got to acquire contrary evidence contained in the emails.
Correct.
Now, you are now quote unquote the judge, because these two things are, at least at face value, they look like they are contradicting each other. You then had to assess, that's your job, is to assess the evidence, as you said earlier, correct?
Yes, the investigator, but yes, under
Yeah,
my
yeah.
direction.
So
Who will
yes, when I say
read-
you now, I mean
Yes.
in plural.
We'll
public
read
protector.
all the, yeah.
Yes, okay, good. All right,
Besides the email, as the chairperson, remember the evidence of one of the people who donated and who was part of one of the dinners.
yes, okay. At least you also have a warm body, as it were. Okay. Now, the process of now assessing the evidence, I just want to make this remark. You've seen, even in this committee, and I'll use an example of what transpired, I think it was with Mr. Matabuche, because this is a core issue of what the difference between the majority judgment and the minority judgment. I'll use this example. You remember Mr. Matabuche gave evidence about whether or not he had seen, not necessarily read, whether he had seen the IGI report.
Correct.
Yes. And then he wasn't sure, and so on. Advocate Bauer then at some stage showed him an email where he was copied, where reference was made to that email, or rather to that report, correct?
Correct.
Then he said, oh yeah, now that you bring it to my attention, I saw the thing, but I did not read it. So something like that. Right, yeah, okay. Now, I'm not going into Mr. Matabuche's evidence for now. I'm just saying that as a matter of testing evidence, what Advocate Bauer was doing is acceptable. In other words, if I come here and I say, I don't know Mr. Shabalala, I've never spoken to him. In fact, I don't even know who he is. You are entitled to say, yeah, but here you sent him an email yesterday and so on. And then I might say, oh, I didn't know it was that Mr. Shabalala or whatever it is. So that's one of the central issues in this case, as to whether that method of logic is valid, of hearing a version from somebody, and then when you have the objective evidence of an email that is not denied, then you can test it. That's more or less the methodology that you were using, correct?
That's the methodology actually in what happened, what should have happened, the discrepancy between what happened and what should have happened, and what evidence you have in front of you. So basically, most of the time, that's our daily operations.
Yeah, good. All right. So then let's go to some of the monies that exchanged hands here.
I think we can also say that the AFG2, they said they confirmed that after Ms. Nicole requested them to open the account, she's the one who used to call them or arrange with them how to disperse the monies. So, so since we were following this 500,000, which was one of the matters which we had to look into, then we had to subpoena the bank statements.
Good. Okay. So this is now a new source of evidence, as it were. You have the testimonies of the people, we have the emails, and now we have bank statements.
Correct.
Okay. In the spirit of following the money or following the evidence, a la mail and guardian, correct?
Million Garden, yes.
Mail and guardian case. Yeah. All right. So now let's then go to some of the recipients or beneficiaries. I think that's what you call them, of the amount. If you go to 5.3.10.60, page 82 of the report. Sorry, Chair. Okay. Okay, before we get to that list of monies, can we just round this up? We left your statement after you read out those names at page 26, rather paragraph 260.
Okay.
Let's go a little bit up, a little bit down or whatever. Yeah. Okay, that's fine. I'm just for members to know that this paragraph follows the one that where we had left the statement. Yeah. Okay. And this is just two paragraphs which I want you to go through so that we don't come back to the contents of the emails. This is, if you like, a cross section of the emails, and which indicated to you that the president knew what was going on. We'll come to that later. But can you place those two paragraphs on the record?
Yes.
260 and 261.
Okay, so the 260, there's the email, there was another email which was the further evidence that showed that on the 12th of November 2017, Ms. Nichols had sent an email to the president stating that Stavros says the following will fund if we had a small cocktail party. I need to discuss diary with you. And then 261, during the investigation, there was a further uncontested email from President Ramaphosa to a person named Donald, which stated the following. Hi, Donald. Thank you for assisting with the internet banking the other day. Could you kindly transfer an amount?
Sorry, can you? That's what?
Okay.
Okay,
Yeah,
take
just
it
go
up
up.
until
Yeah,
the
don't
account
show
number.
it. Yeah.
Show the
Just go
account
up.
Yes,
numbers.
yeah.
Just little.
When I say until, I mean excluding. Yeah, thanks, Chair.
Until account number. Yeah.
Yes, right there. Okay.
Yeah. You can push it up a little bit. Yeah.
No, if
Oh,
you
yeah.
push it further than that,
It will
the
show,
account number
okay.
will show.
So could you kindly transfer an amount of 20 million from the money market investment that was left after we shifted 75 million from the money market select to reattender trust Standard Bank account?
Account number, blah,
Account
blah.
number, sorry, and so, and then I shall call you to confirm all this, Cyril.
Yes, okay. Okay, I'm trying to be creative here, Chair. Okay, can you now move it up, but the account number must still not show. So
Yeah, it
that's,
doesn't show.
yeah. Yes, okay, that's perfect. That's perfect. Well done, Sepo. Yeah. So, okay, apart from the sentence that we have for obvious reasons not taken out, the last is Cyril, meaning that's the sender of the email, correct?
That's correct.
Good. All right. Now then we can go to
262.
262. Yes, 262, so that we just get there's no account number, just the entities here, correct?
That's correct.
Mm.
The investigation revealed that several accounts were used to mobilize funds for the CR17 campaign. This included Reatenda Trust, Edelstein Faber Krobler, EFG Incorporated, and a company called Linked Environmental Services.
Mhm.
So then 263, some of the beneficiaries of the donations were senior members of the ANC and officials or functionaries of the CR17 campaign, which included Ms. Marion Spark, Mr. Mkhwebane Dukwana, Ms. Busisiwe, and Ms. Kumbutso Nchaveni.
Mhm.
Yes. So 264 millions of rands in excess of 8 million were used to fund only hotel accommodation for several delegates who attended the ANC National Conference in December 2017 in and around Johannesburg.
Okay, just
Yeah.
pause there. Again, it's just my interposing so that people follow the sequence. So we know that we've established that that 500,000 was paid in October 2017, and then the email about the small cocktail party. The people who said they'll fund only if the president comes to a small cocktail party. That is in November.
That's correct.
Okay, that's now a month before the conference.
And I think it should be clear that we were following the 500,000.
Yes,
And
yes.
unfortunately, then when we analyzed the evidence, then we had to uncover something like this.
All this, yeah, okay. So then it got bigger and bigger.
Mm.
All right, fair enough. And I just wanted to situate the sequence. So it's October, November, and then the paragraph that you've just read now, talking about paying rent for delegates. These are now delegates to the conference. According to that, this is now December 2018. Correct. Okay, that's fine. Makes sense because I know that the conference in December 17. It says 8 million was used to fund accommodation for delegates. We don't know what kind of accommodation it was, but it's either a very posh accommodation or many people, whichever it is, yeah. But the figure was 8 million.
That's correct. Remember the bank situation paid where it was also by Mkhwebane interviewing him because saying some money was used for food, for accommodation and all.
Yeah. All right, 265.
Very important economic player, the South African economy paid millions of rands in the campaign, CR17 campaign, raising reasonable that they were and from those and several officials and functionaries of the CR17 campaign, large of money. We analyze the bank statement and we could see it move from where to where and how.
All right.
Then I
260.
I put here and state that records, which include emails and records, which I tend to rely on as evidence, were sealed by the High Court in order to prevent them from being made public. It was done.
Yes.
Members by the deputy.
That's what I was mentioning earlier.
Yes.
So those bank statements, bank records, and so on, we'll just use them before they were correct.
Is still
Analyzed.
yes, uh, after we issue the report, we then saw some information published in the various before sealing it was confirming whoever fitted, whoever donated.
Okay, thanks. We'll do that. Yeah. I think it is away from the high courts, the that's in the yeah. All right, 267.
Over and above showing how money was moved around, there's records that as the version, the president was ignorant of the identity of the donors of the CR7 campaign. Because this anyway, we will, when we go to the constitutional court judgment, because we avail of information to the constitutional court.
So now getting closer to what I call observation. Before we do that, just to round off previous issue, go to H, public protector 31.7.1 and 31.7.2. I think this should work. Public protector. She also 0.7 this point. So that would then be a paper. Just move it up. Take out the please.
Bauer,
Sorry, Chair.
Advocate Bauer. Pause.
This appears to be a media report. And it's hearsay, so I'm checking the extent of Pofu is now seeking to rely on media reports as opposed to of the script of what was before the public protector and the report and the affidavit. I have some difficulty on the reliance placed on media reports.
Okay, thank you. Madam Boff.
No, thank you. No, if you allow this, because it's let me tell you what purpose is here. Purpose is, as I said, we can't use the evidence that's in that is sealed for obvious reasons. But I want to. I'm not using the newspaper report, let's say, for whatever it was reporting. Let's say the newspaper report was from yesterday, and I've said to you earlier that whatever would have happened yesterday would then not feature in what we're analyzing. But I'm using it for a different purpose, which is to test the evidence that was at the disposal of this witness at the relevant time, not now. The fact that it came out yesterday or whatever is not relevant. That's number one. Number two, I'm not using it to test the veracity of the newspaper report, which is where the hearsay rule would apply. So it's just to reference the fact that because we're busy here in this inquiry, inquiring into what factors and what evidence was playing in the public protector's mind for her to get into the impugned or the conclusions that are before this committee. So that's really the only purpose. It's a limited purpose. Thank you.
Okay, back to you, Advocate Bauer.
The report comes out in July 2019. This media article is written August 2019. So
Yes.
I have difficulty with firstly, the hearsay nature of the media report, the slant that's put onto media reports, which we know one can go and dig and find media reports. It's going to tell you depending on how the author writes it. And thirdly, the public protector can tell us what she had in her mind at the time without resorting to the hearsay evidence of a media report.
Yeah, okay. I hear you, Advocate Bauer, I think. I've got them both.
Chair, well, I don't want to preempt you. If you, I'll only talk if you're not going to allow me to ask the question.
You can ask the question.
Okay, thank you, thank you. You heard that, but we do need to be careful. Advocate Bauer is right, yeah. So again, just so that we disclaim any ownership of the media report. We are not here to verify the truthfulness. The journalist can say whatever he or she said in the article. That's not what we want the committee to now adopt, or whatever the journalist was saying. I'm saying the only reason we're bringing this, and number two, Advocate Bauer is also right, that technically, if the report came even a day after the report, then obviously that report did not inform your report. That's just a matter of logic. Did you understand what I'm saying? If the newspaper report came even one day after the PP's report, then obviously it did not play any part in the report. You accept that?
Yes, it's correct.
Yeah.
Indeed, we don't normally rely on what the media publishes.
Yes. Yeah.
Because as I said, information in the media is information.
Yeah.
We go deeper and investigate.
Yeah.
But if you can hear what I said earlier, that there's somewhere where I mentioned that before the sealing, after we issued the report, there were publications of some of the information,
That's it.
which is I've read here, especially the names and everything, which I can confirm that
Yes.
indeed it was published before the sealing, and indeed it's evidence which was
Before
me.
you.
Yes.
That's all. Yeah. No, I'm assisting the chair to say that when it's allowing me to, it's for that limited purpose. Yeah. Okay. Thank you. Or assuring Advocate Bauer rather than assisting the chair. Yeah.
Advocate Bauer, just pause, Advocate both.
Chair, based on that, this
Oh.
Just
okay. Chair, no, it's not. It's nothing of the sort. I don't. It's frustrating. We are trying to get into the truth here, but in doing so, we can't use the committee, as it were, to unseal documents that have been sealed. The witness has made it clear that she had certain information in front of her, and that information was published in these articles, which she is aware of long before the sealing. That's really the only purpose of this. Otherwise I can just ask her to read it out herself, or I can read it and ask her, and then she'll confirm. It's the same thing. It's a facilitation of evidence. It's got nothing to do with the truth of the newspaper report. It's the existence, and Advocate Bauer knows this. There's a difference between invoking a newspaper report for the truth of its contents and the mere existence thereof. There's a big difference. The hearsay rule doesn't apply if you only want to establish that the report was made, not that it's true.
it's important that we stick to what you said at the beginning of what we're not doing here. But I'll give Advocate Bauer before I go to Public Protector.
Chair, one of the reasons for the sealing was the ambit of the Public Protector's investigation, and what the court eventually held was the case and confirmed by the Constitutional Court subsequently as to what was permissible to be investigated under EMEA, and the fact that party political funding didn't fall within that ambit, and a number of the allegations in this media article does go to the expansive funding that went into the CR17 fund as opposed to what was actually being investigated by the public protector. Over and above that, I don't agree with Advocate Mpofu's position, because he is going to rely on the contents of the media article.
Okay, so just your summary of your concretely what your concern and intervention is on.
Chair, my concern is that the media article was not one of the source documents that was before the public protector at the time of a report. It doesn't pertain specifically to the subject of the report, and it's not on which the basis of the misconduct and incompetence allegations rests before this committee. So there's nothing in this article that relates to what is before the subject matter of this committee.
Okay, yeah, we'll find we'll have to find a very proper and creative way, Advocate Mpofu,
Yes.
because I do hear what
so do I,
Advocate
Chair.
Mpofu, Advocate Bawa is placing, which is very important.
Yes, no, so do I, Chair.
I'm going to try and lean on you
Yes.
to.
I'll find a creative way of doing it, Chair, that is not going to stray into that issue. But one thing I must make clear is that I am not relying on the veracity of the newspaper report, number one. Number two, we are busy inquiring into what was before the public protector. And I am specifically disavowed any, if we remember, the public protector had access to these sealed documents, Chair. So we could have just said, oh, well, she's got it and here it is, or put it up in the public protector statement, but that would be wrong. So we don't want to do that. All we're doing now is to say, public protector, enriching these conclusions for which you are now being impeached, what information was at your disposal? That's really the only purpose. And I thought your ruling made it clear. It's the only limited purpose of leading this evidence. So anybody who's interested in the truth and in what objectively was in fact in front of the public protector, I don't know who is being protected now. But
No.
I think let's protect the the process.
Nobody's being protected.
Well,
we're protecting our process.
Yes,
as a committee.
There were on
so,
one.
so that you don't put personalities into it.
Okay, good.
It is our process.
Yeah.
Because that's a process that can easily be reviewed if we don't do it properly.
Yes.
You are going to interact.
I speak.
Yes. Yes, I think the chair has given you a platform.
Yes, Chairperson and members of the committee. I think I'll ask Advocate Mpofu again to read the charge which I'm facing regarding this matter. And remember, as the committee, you said it, you represent members of the public, and the public as well, they are listening, those who are listening, and they want to know the truth. And this is for me a matter of life and death, because this is about me. I'm the one who's sitting in this stand. I'm being accused of gross negligence. I'm being accused of targeting people. I'm being accused of misconduct. And I think if you go back to the charge, Chairperson, this is what I'm trying to prove, that the evidence which was before me.
This is now 11.3 and 11.4. That's the charge.
Correctly.
Patently wrong finding on money laundering, doubting of bona fides of the president without reason. That's the charge.
Correctly.
Yes.
Okay.
That's correct.
Sense. Yeah.
So, and remember yesterday, I also said, I have been subjected to this persecution, false reporting. Yes, the very same thing you are reading now, because other people, they take it as is. Now Advocate Bauer comes and say the court found that that was, because that's what the court is saying.
Hmm.
And again, those are the facts I don't agree with, because it's in the report. Hence, I said I will deal with the report. I will deal with, at the time, Chairperson, what I was dealing with. Hence, I'm saying the president was the deputy president of the country. The president was subjected to Executive Members Ethics Act. And the president was a member of parliament. And there's a legislation we've mentioned there where we were requesting the speaker to do something, because the president and any of you, even if it's 350, you need to declare to parliament. The investigation at that time was purely based on that. Hence, I'm saying now that on that factual issue, unfortunately, the court got it wrong that I'm investigating the private ANC funding and everything. But even the president himself said to the speaker, that was relating to the ANC campaign and being a leader of the country, which is being the president. So what I was trying to show is that the untouchables, some of them being in the big business, which yes, the information has been sealed, and hence I'm saying again, the process which was followed in sealing them, which we never agreed with when we were litigating, because it was just sealed in chambers. It was never an issue where both we submit and both it's argued and we see, okay, which information is critical for me to defend myself. So the information which is out there, not to say I relied on the media, that definitely we don't do. What is there in the media after the report is issued, I'm confirming, or I'm trying to prove here that I'm being persecuted, or these untouchables who have donated and who are then also then protected. But my life is in danger here. Well, danger in the sense that indeed it's a matter of life and death, because this is about my future. So the media article, I was going to confirm that indeed the following people were the people who donated or who benefited because of the evidence which was before me. It's not because I'm relying on the media statement, but I'm saying what is published, the information indeed is correct. So it was purely that.
Oh, okay, thank you, Public Protector. I see the hand of Honorable Myla.
Thank you, Chairperson. Chairperson, I just want to correct a factual matter, and that is that the President is not a member of Parliament in terms of Section 87 of the Constitution. That when a member is elected as the President, he ceases to be a member of Parliament at that time. Thank you, Chair.
No, wait. No, thanks for that, Honorable Myla. That would be correct, but if you situate back, then the issue is, which is the argument that at the time. Okay, no, I'm just following, boss. She would have done that before and said at the time, even now she did say at the time he was a deputy president.
Thank you.
And at that time he's a member of Parliament. So just to correct that, Honorable Mola, I see your hand.
No, Chair, I just want to confirm what you've just said. The PP said the president was the deputy president at the time and the member of Parliament. So I just wanted to confirm what you said.
All right. Thank you.
Thank you, Chair.
Advocate Bow. Oh, sorry.
Chair, Advocate Mpofo said he's not going to rely on the contents of the article. The Public Protector has now said she is relying on the contents of the article. But she
Chair.
does want to refer to the names etc. in the article.
No.
And who benefited and who donated and who didn't. That's different from what Advocate Mpofu said. And he
Yeah.
said he's not relying on it.
Sure. Let's clear that up.
Yeah.
Advocate Mpofu.
No, Chair, really,
Uh,
I never said that. I said I'm not going to rely on the truthfulness. The hearsay rule is about veracity. You know that that's basic law of evidence. Okay. So if I say there was an article yesterday which says the chairperson beat somebody up in the committee, I can adduce that evidence for two purposes. If I'm adducing it to show that the chairperson indeed beat up somebody, then it's hearsay. But if I'm adducing it for the purposes of showing you that there is an article that says that, whether it's true or not is a different matter. Do you understand the difference? So the hearsay rule does not apply in the first instance. And that's what I meant when I said, of course, I'm not going to rely on the journalists might have their own spin and what have you. I'm not interested in that. All I want is to say that there were these articles which happened as the witnesses actually resolved this by saying those articles were published long before the sealing even happened. So assume there was no sealing that had happened, then this objection would not be coming. So all we want to do is to say these articles came out long before the High Court even got involved in this. And is this part of the information? In fact, we've already done that in the previous paragraph 263, which refers to Ms. Marion Spark and Policy Dukwana and what have you. That's the information that was before the public protector. And we're simply adding other information, which we were just for reference purposes using those articles. But it's not going to change. It doesn't change the fact that the articles are there. The absurdity of this situation, Chair, is that these are articles that are in the public domain, but they must be sealed, quote unquote, here in this committee. I mean, that's just ridiculous. If they are in the public domain, they are in the public domain right now as we speak. So why would we want to run away from them simply because in another context, they form part of sealed information?
That was not my understanding that the such is that it must be sealed here. I didn't get Advocate Bauer to say that, but the key issue is that, which is important for me as a chair of the committee, that in the work we're doing in trying to get to the bottom of issues and to the truth, and also based on what you said at the very beginning, we're not going to use this space to ventilate what would have been sealed. I don't even know what would have been sealed.
You can Google
So we don't utilize the space of this committee to get into, to encroach on those issues. It's very important.
I agree.
Before I go back to you, Advocate Bauer.
Chair, judging from where your ruling essentially on this is, perhaps what we need to do is maybe two things, is link it to which provisions or paragraphs in the report this evidence leads to, and where Advocate Mpofu is then going with this.
All right. You know,
does that help?
Yeah, it does, Chair.
Okay.
In fact, let me do it like this to assist. Maybe
can switch in on again. My apology.
I need to correct something, Chairperson.
Okay.
The evidence leader is saying I said I never said I relied on those media articles. I was just saying the evidence which was before me, and then the report was published, and before the sealing of the evidence, that's what I'm trying to confirm and to prove a point that I am dealing with the untouchables and why I would want us to confirm that this is the evidence which was before me, because all those three bank accounts and how the money went through. And one of the people you'll be showing now, or who was the benefactor, is the sole director of Reatenda, which is in the report, but maybe Advocate Mpofu will show you. It's fine.
No, I think, Chair.
Okay, thank you, Advocate Mpofu.
Yes,
You
Chair.
start here and
Yes,
then you.
yes, yes. No, in fact, I'll start with you, Chair, because I think you are proposing some compromise. I think, sometimes they say a pause resolves a problem, especially when it's non-existent. Yeah. So this is what I'm going to do, Chair, in line with what Advocate Barr is suggesting. I'm going to go into the information that's in the report, and then after lunch, maybe after she has had lunch, or maybe me and her will discuss it here. Then go, in other words, let's assume there are three types of information, Chair. There's the information that we've read in that paragraph. And then there's information that's in the report. Oops. None of that is controversial.
Just pause. Just pause. Honorable
People are having
Jamaat.
lunch already.
No, Honorable Jamaat, please keep your place. I see you, there's a traffic with you. Thank you. Please keep your space. We're about to go to lunch soon.
Yes, yes.
Over to you, Advocate Mpofu.
Thank you, Chair. So I was saying we have three types of information. There's the paragraph that I read. There's the information in the report. Those are not, there's no controversy. The only controversy is around this, the third type. Yeah. So I'm going to pack this third type and we'll deal with it after lunch. So what I'm going to do now is to deal with the information that is not controversial, that is in the.
Okay, go ahead.
Yes.
Thank you. And I'm also trying to protect you from Honorable Jamaat.
Yes, please, Chair. Yeah, please. Yeah. That's why I'm sitting like this. No, it's okay. Right. Okay. Public Protector. Let's, because I just don't want to waste the time of the committee, and because later I'm going to be making requests from the chair, seeing that we're traveling today. So I want to be in his good books. Yeah. So this is what I'm going to do. I'm going to take you to some of the, Advocate Bauer says where in the report. So let's go to the report. Yeah. And then if there's anything outstanding, we'll then go to the. Can you go to, oh, sorry.
Yes.
Just maybe to assist Advocate Mpofu, I don't have an issue to I know what you're trying to break down the amounts stuff in the report. Maybe I'm preempting.
Yeah, we'll discuss it at lunch.
Yeah.
That's fine. Let's not involve the committee.
Proceed.
Thank you. Can we go to paragraph 82? I'm sorry, page 82, Tsepo, of the report. Paragraph 5.3.10.60 pp.
Okay.
Right. Okay. So let's use the root of the report here. So the heading there says, yeah, evidence on the disbursements of funds from EFG2 trust account to several beneficiaries, including Reatenda Trust, Linked Environmental Services, and the Cyril Ramaphosa Foundation.
Correct.
Right. Okay. So can we then go through those disbursements, which is the information that was in front of you? Okay. Let's not read the first paragraph because we're almost at lunchtime. So I'll paraphrase. That's the information that you subpoenaed from EFG2.
Yes, the bank records.
The bank records, right? Okay. And then the easy one that we've spoken about all morning is 5.3.1061. That's the 500,000. We've spoken about that.
Correct. That was transferred from Mr. Watson's personal account.
Mm-hmm.
actually, the 3 million was also confusing because it was 3 million into Mioto trading.
Hmm.
And then eventually into the EFG2 trust account, it was only 500,000. So the other 2.5 million was for other payments,
Yes. All right.
not to the donations, but their operations as Busasa.
Right. Okay. Yes. Yes. Okay. I remember that. And then this at maybe let's start reading from 5.3.10.62. We might not be able to read all of this, but we'll continue after lunch. So can you read that out?
I can also confirm that large sums of money were transferred by various benefactors into EFG2 trust account for the CR17 campaign, from where it was dispersed by the attorneys to several beneficiaries, including Riatenda Trust, Linked Environmental Services, and Cyril Ramaphosa Foundation, to name a few.
Right. Okay. Now then we get to the
Maybe before we get to that, I think even in the report, we will find it, and just for Honorable Mailham's benefit, where we are specifically clear that we are investigating the president as the deputy president by then. Hence, I said I don't agree with the facts which were portrayed in court or in the court judgment. Thanks.
Yes. No, I think Honorable Amailam understands that now. I said somewhere in the morning, maybe he was not here yet, was that we are, when I say the president, I just mean the president today, like President Ramaphosa. But the report was about him as deputy president. So otherwise we'll all get confused. Now we have to remember to call him deputy president or to call him president. I think everyone understands that. Yeah.
Correct.
Thank you. Yeah. All right. In fact, even in the judgment, they call him the president, but it's on this understanding. Yeah.
Mm.
All right. Then the next thing is then, if you can go through those figures, big figures. I hope you don't have that problem of
just read the first three.
Certain former president.
So from the evidence received by my office, an amount of 191,482,227.43 was deposited into this EFG2 ABSA trust account between 6 December 2016 and 1 January 2018. So it was almost a period of 2 years or 1 year, some months. And the 190,108,227 was transferred out of this account in the same period. So due to it was a very complicated financial analysis process. So, and having a lawyer investigating the matter, it was difficult for us to just, because we should have all the information. And I mean, these 190 million who were paid for that. So we just summarize key issues. Yeah.
Okay, fair enough. In other words, we did what to call bush accounting. No, I know. It looks like the people who have problems with figures are us lawyers and presidents. Yeah. Because even the current president is struggling with the figures. Yeah. All right. So, okay, but in any event, let's not get into all that whole list. Let's use that one so that we can then break for lunch. Let's just use that one as a let's call it as a model of the point you're making, which is that you said there was an amount which came in. Let's call it that for those of us who are not accountants. There's an amount which came in of about 191 million, and it's dispersed, and those disbursements are almost around the same figure, another 190 million, give or take a few rands and cents.
Correct.
So you're able, yeah, I remember this is the worst thing when you actually study accounting. It's when the figures don't actually balance. But roughly, you could see that this is the money that came in and this is the money that came out.
Okay. Yes.
All right, good. Okay. I
And
don't
then
think
the next paragraph.
yeah. The next paragraph then is so the first, that's the amount of 190 million. The next one.
Then the next one, evidence from bank records again reflect that an amount of 388,544,340.34 was deposited into Standard Bank South Africa of Ria Tender Trust account between 1 January 2017 and 20 February 2019. So it's a period of what, 2 years almost. And then from that, almost 388,518,464.55 was transferred out of it in the same period.
Yes. Can I ask, with the permission of the chair, you don't have to read those rands and cents at the end. We all understand that you are lawyers, the figures didn't balance to the last cent. So you can say 388 million and then we just move, yeah.
Okay.
Yeah, he's
So that-
interested in the millions. So.
Yes.
Yes, so that's what we discovered.
Mhm.
And then the next one is records also reflect that there was a 441 million
Mhm.
which was deposited into the FNB account of Linked Environmental Services
Ah,
between 15 December 2016 and 13 February 2019.
mm.
And during the same period, an amount of 441,147, was transferred out of this account during the same period.
Okay, so next one.
And then there was an amount of 335 million was transferred. In fact, is it million? Eh? Transferred from Linked Environmental Services FNB account.
Yeah.
It's 335,000 or
Yes.
million.
Uh,
Gabon,
Sorry, that's that's which province are you from?
mm,
There's a
From
problem.
Mpumalanga.
Oh, Mpumalanga, they can do
Yes.
these things. Yeah. All right. I think it's only Advocate Shabalala.
KZN.
All right. No, I think that one, the point we're going to assume that the comma is after the 738. Yeah.
Yes.
So,
Okay, so it's
let's say 335,000. Yeah. So
Was
I think the chair is
transferred,
right. Yeah. Okay.
from
next
this
one.
linked services into Cyril Ramaphosa Foundation between 20 July
Mhm.
2017 and 26 March 2018.
Right. And then the last one.
The last one was, out of all the donations received for the campaign, records reflect that there were 3 single largest donations of 30 million on the 9th of March 2017, 39,620,000 on the 29th of September 2017, and 51 million on the same date into EFG2 ABSA trust account. And that came from the same donor.
All right. Then the punchline from which we will take this when we come back from lunch is at 5.3.10.67. If you can read that into the record.
In conclusion, on the above revelations relating to exchanges of large sums of money, some of which received from private companies, I wish to express my preliminary view that such a scenario, when looked at carefully, creates a situation of the risk of some sort of state capture by those donating these monies to the campaign.
Right. So that's your finding.
Yes.
Having done all the analysis and the accounting and the moving the money from this one to the other. And sorry, Chief, just for the sake of completion, that language of something that could create a situation of the risk of some sort of state capture or conflict or some wrongdoing or whatever, mirrors the prohibition that is placed on members of the cabinet in section 96 of the Constitution. And we can start from there after lunch.
That's correct, because
Yeah.
when we go to the legal framework
Mhm.
and the applicability of EMIA and section 96, that's what we were basing our findings on.
Thank you. And well, okay, now I'm stretching my luck. You can confirm that I think in the Nkandla judgment, Chief Justice Mkhwebane had said that what is prohibited is not so much that the risk must materialize, but the risk of such a conflict is sufficient to breach section 96 on the part, in that case, of the former President Zuma, correct?
That's correct. Actually, it's how even the Executive Members Ethics Act is crafted. You just need you shouldn't expose yourself,
To the risk.
even if it doesn't materialize that risk, but you should just stay away.
Okay, thank you, Chair.
Okay.
We'll start from there.
Thank you. We'll take lunch for the next 45 minutes back at 2. Thank you. Colleagues, welcome back from lunch. We resume our session with Advocate Mkhwebane, led by Advocate Mpofu. Over to you, Advocate Mpofu.
Thank you, Chair. Chairperson, yes, I'm happy to announce that the intervention of the lunch hour has, we managed to resolve a small impasse. And so for what it's worth, Chair, the information, or at least we've agreed that I can use those articles still on the limited basis that I described. But I just thought, just for what it's worth, Chair, is to assure everyone that even on the basis of the limited agreement we had before lunch, there's nothing wrong with leading the information. And that, if you remember, Chair, we finished at 5.3.10.67, Tsapo. Yeah. Just go slightly up or down or whatever. I never know the direction of this. Yeah. Okay. Chair, just wanted to show that the next part where the lunch intervened after I had read that paragraph. So below, you say, it says below is the depiction of the flow of funds from EFG to trust account here. So that is a complicated graph which actually has the same information that I'm going to deal with. So I just wanted to assure everyone that it's not something outside of the report. Thank you, Chair. All right. So now can we go to we were before. No, you can move from that. I was just to address the Chair. Where we had that controversy, we were at bundle H, PP folder item 31.7.1 and 31.7.2. Right. Sorry, Chair, just want to. All right. Can you go to the next one? The next article. The next article, I think, is 31.7 point. So 1.7.2. If that one was 0.1. Please, Chair, please bear with me. I just, that article is just dealing with one specific person. So I don't think it's necessary to. And it's a minister and so on. All right. No. So much for trying to avoid exactly that. Please remove that face. Is that one, if that one was 31.7.1, yeah, now 1.2. Or is that 0.2? Then look for 0.1. Right. So that's an article as Advocate Bauer indicated of 11th August 2019. That's just a few weeks after the report, which was from the Sunday Independent, from some investigative journalists, and it really basically shows some of the information flow, or rather of the money flows that have been referred to, some of which we went through before lunch. And also it shows some of the persons that we had already referred to. So on the left-hand side, we have the people that they refer to as some of the campaign managers, excuse me, and political activists who benefited. And Chair, again, just for the sake of fairness, you'll see that in the statement we also used the term recipients, and we did that deliberately because we don't want people to be just blamed for nothing. So it might be that the mere fact that you are a recipient of 20 million, we just want to make clear, it doesn't mean you took it and used it for your own family necessarily. They may or may not have done that. So that's not what we're trying to see. So I prefer the word recipients than benefiting. All right. So we have then the person there who's identified as Minister Mkhwebane. There's Marion Spark that we mentioned earlier, Mr. Kodongwana and Mr. Tukwana. Okay. And then on the funders, some of the main funders, that's the area that we didn't deal with. There's was this the information that was at your disposal, Public Protector?
Yes, the bank statements, that's what they were revealing.
Right. Okay, maybe you should then, I've just summarized the names of the, are you able to see?
Yes, I'm trying,
Okay.
but I also need to indicate that besides this article, I think there was another article of either Mail and Guardian or Daily Maverick, which
Yes.
also had a lot of other details, but this one was just showing these few individuals. Yeah.
Yes. No, fine. We'll I just wanted to confirm maybe some of the figures that are there. On the recipient side.
The recipient side, my eyes are failing me. I don't see properly. Yeah, even after
It's not
the
visible,
glasses.
Chair. I'm going to
just
unless
check
if there's an objection, I'll read it myself. Okay. Under the recipient Mkhwebane, it says 5 million, right?
Yeah, we can see the figures.
You can.
Here,
Yeah.
yeah.
No, it looks like the chair is struggling. I mean, not the chair. The witness is struggling with seeing.
Yes, please. Yeah, that's what I said.
Okay, under Mkhwebane, it's 5 million rand, correct?
Yes, that's correct.
And,
because as I said earlier, that she was I think she was the sole director of Reatenda.
sorry?
She was the sole director of Reatenda.
Oh,
By
yes,
then,
of this
that's why I mentioned earlier.
Yes, the
that-
company that had been mentioned, yeah,
Yes.
called Reatenda. Okay.
Mm.
Then the other one is Marion's Park, is 24 million rand,
It's 2.4.
2.4, okay.
Supposed to be 2.4 because I think there was a daily monthly amount which was paid.
Right.
Mm.
Okay. Then Deputy Minister in the Presidency, 2.3 million or 23,
2.3.
2.3, okay.
Yes.
Then it was Minister Kotongwana 400,000
Yes.
and Mr. Tukwana 600,000.
Yes.
Now, and the beneficiaries, I'm sorry, and the funders,
Yes. According to the bank statements, that's what it was reflecting. The individuals like I remember the Maria Ramos. There's think there was also here it's not showing, but then in the other ones they also show Rupert, the Oppenheimer, and
yeah, the first face there is Mr. Nicky Oppenheimer, correct?
yes,
Mhm.
and then there's also this other. It's Copeland or Copeland.
Yeah, Johnny
Yes.
Copeland,
Yes,
mhm.
and then
Raymond Ackerman,
yes, definitely. They
and
were also
Mark
the,
Lambetti.
yes, in the statement they were there.
Okay, and then that person, whose first name is Stavros there. Stavros
Yes.
Nicolaou, that's the, well, at least the first name is the one that was in the email that you
In
read
the email, yes.
before
Donna.
lunch.
Yes.
Okay.
Mm.
Okay, as promised to the chair, I'm not going to talk much about the narrative,
Okay.
because that's what the journalist, that's the journalist's take on it, yeah. But just the dry figures there. If you go further down, you mentioned yesterday, there's somebody called Mike Tech. There's an amount there next to Johnny Copeland. What does that name ring a bell?
Yes, it does. That's why I'm saying I think the Daily Maverick one or the Daily Maverick or Mail and Guardian had also other yes, companies which donated and individuals.
Persons, yes.
Yes.
Goldman Sachs, Tifiso Tabengwa and people like that. Okay,
Yes,
we'll get
yes,
that.
yes,
Okay, to
yeah.
save time, Chair, can
Actually, it
can you
had a
pack
lot of
this?
individuals.
So that, because I think I was not sure if we were going to reach an agreement with the evidence leaders. We'll come to that. I think the picture in any event is clear that you had
Just a pause. That we're
Sorry,
gonna go for, Honorable Mola.
No, Chair, I saw in there that the article that was shown there was written by a certain journalist by the name of Pete Rampedi.
By the name of?
Pete Rampedi.
Yes.
So I wanted to check that is it the same person who wrote a fictitious article about 10 kids in a certain hospital in Gauteng.
Okay. Well, there would not be anybody who will be able to answer here on that. Or, you know.
yeah,
Okay.
I can answer.
Okay.
No, I
Advocate
think-
Both,
Chair,
just
yeah,
this is more of a clarity.
I think it's just I think we must demote him from deputy chair. No, I think it's back to becoming
Proceed, Advocate Both.
Yes, it's back to becoming an ordinary member. Yes. Thank you, Chair. Yes. No, these are very serious investigative journalists. Ziligazwa Africa. Ziligazwa Africa is the ace investigative journalist in South Africa. Mr. Rampedi, that he wants to make controversial because of one story, has got one of the most illustrious careers, starting with the Sunday Times and various other. And then
Please don't be
Karabo Mkhwebane, I don't know.
Don't be distracted,
Okay,
please.
yes, thank you, Chair. Thank you. Thanks for the projection, Chair. Yeah, I'll ignore the former deputy chair. All right. Now, I was saying, public protector, in a nutshell, without necessarily going into the minute details now, we will get that other article that you're saying is more helpful. But bottom line is, you had before you information which corresponds with this in respect of, it might not be, this might not be 100% of the information, whatever percentage it is, but it coincides with the information that was before you in respect of both the recipients, as I prefer to call them, instead of beneficiaries, and the funders.
Yes, that's correct. Hence, I said this is correct what they've reflected there, and then there's
more.
Yes.
Okay, good. I think that's clear then. Fine. If if we get to the stage where we deal with that more, we'll get to it. But I want us to move on from this now. All right. Thank you, Chairperson. Now, then in your statement, you then go on to deal with the judgments, or rather, yes, the judgments, correct?
That's correct.
And there are two topics that I want to deal with in relation to the judgments. The one relates to the real issue in this entire matter, which is that, if you remember that matrix we had earlier, the evidence before you, including what we've just discussed, versus the version. You remember that?
Yes.
Yeah,
the
and by the
complaint.
version, we mean what was said by the president, what was said by the campaign managers and those types of people.
And the evidence which we independently acquired.
Yes, and the bank statements and yes, the bank statements. All right. So that's the one thing we'll deal with. The second one, which hopefully we'll get into as well, relates to the other topic about the code.
Yes.
Okay, because that's an important issue for this committee in particular, because it's one of the bases upon which you were severely criticized in the, I think, let's just say in both judgments, the majority judgment and the High Court judgment, that whole confusion about whether it's a 2000 code or the 2007 code. So that's the second topic we'll deal with.
Okay.
Okay, good. Right. Now, Chair, if we can then move to the statement. Right, let's go to 282 of the statement.
Page and paragraph.
Oh, sorry, page 620, paragraph 282, small page 124. Right. Okay, the previous page is basically all those big figures we were reading earlier, so we won't go through them. So from 282 onwards, this you put into perspective why you would like at the end when we do the legal argument to convince the committee that the minority judgment, despite its obvious legal status, is more in accordance with the evidence that was before you, correct?
Correct.
Okay, so can you read from 282 onwards?
Okay, in conclusion on the above revelations in relation to exchanges of large sums of money, some of which received from private companies, I wish to express my preliminary view that such a scenario, when looked at carefully, creates a situation of the risks of some sort of state capture by those donating these amounts to the campaign, as properly articulated in the minority judgment of Chief Justice Mkhwebane, which I am in total agreement with.
Right. Okay, that's the point you made just before lunch. Okay, carry on.
So I will also seek to convince the committee that upon any objective inquiry, there will be no option but to endorse the views expressed in the minority judgment, whilst acknowledging the legal status of the minority judgment.
No, of the majority.
Of the majority judgment, yes. Whilst acknowledging the legal status of the majority judgment. That exercise is in turn dependent upon whether the committee adopts the view that its role is to rubber stamp the relevant court judgments or to independently inquire into the issues raised in the charges.
Yes, if you can pause there so that I can just address the chair. Chair, that is a reference to that. That's why I was saying we don't want to smuggle our legal debates through the witness. That issue will be debated, I'm sure, for a long time when we do the legal arguments as to what is the status of the judgments and so on. But for now, I'd like the committee to proceed on the assumption that we will convince you at that stage that the judgments can be inquired into. Thank you. Okay, carry on.
Okay, so based on the facts alluded to above, as well as evidence adduced during the investigation, my team came to the conclusion that there was merit to the allegation relating to the suspicion of money laundering, violation of the Ethics Executive Code, and that the president personally benefited from the CR17 campaign donations. So that was based on the evidence before us.
Yes.
So 285, it is notable that Mr. Mataboge, Rodney Mataboge, who was the lead investigator, independently came to the same conclusion. His evidence to that effect was unchallenged.
Right.
So I think Rodney was one of the witnesses, and I indicated that him being the lead investigator was also to make sure that we protect the information and the evidence, especially because we were dealing with the president.
Yes. Okay, maybe let's pause there. Yes, you'll remember, the committee will remember at least that Mr. Mataboge evidence was led on this, and there was that whole thing of that there was he was not part of any conspiracy, at least assuming you were part of some conspiracy, that he was not a member of that conspiracy. And that evidence was not challenged. So, but now something that you just mentioned now, the significance of the fact that you were investigating the president of the country, what is the significance of that?
That is very much important because I think, again, it was captured in the Nkandla judgment that the president is an embodiment of the Constitution. And is a very high, high office of the land. And to protect the integrity of the investigation and to protect the president, but as well anything relating to the investigation. It was very critical that at least there are few people who are dealing with this investigation. Hence, I indicated earlier that even the Chief Operating Officer, Basani Baloyi, she was only taken through the Section 7(9), which we were going to discuss with the president. So she was part of that meeting. But all the information and the details was the responsibility of the lead investigator. I must also indicate that it's one person also who was requested to assist with the Excel information on how the calculations can be made, but that was it.
Yes. And Chair, again, for the record, don't want to belabor these points. For the record, we acknowledge when we talk about the president in that context, that insofar as the CR17 issue is concerned, he was deputy president. But insofar as the Maimane question was concerned, he was already the president. So just in fairness to the issue that Mr. Mailam was raising. So we don't have to repeat that. We understand that.
Yes.
Okay, good.
Maybe let me just say that even with the current Pala investigation, also to protect the credibility and the, having few people who are dealing with the information or the evidence. Also, the chief investigator was allocated to deal with this investigation.
Oh, so before your suspension, from what you're saying, should we understand that before your suspension on the 9th of June, the Pala matter was already allocated to a particular chief investigator?
Yes, definitely. The one, I remember we prepared even the 31 questions, and those were the questions which were sent to the president.
Yes.
Again, it's a question of the seniority and the question of experience and protocol. Yeah.
Okay, good. So, in other words, it was not yes, because I think in fairness, Ms. Bauer did put the question to Mr. Matabuche as to why that investigation didn't follow the normal chief investigator, senior investigator, and so on and so on. So, from what you're saying, should we understand that with both Pala and Busasa, there were those considerations that you are dealing with the president?
Definitely.
Okay. And apart from the protocol issues and seniority issues, one should not read anything into the fewer number of people getting involved.
No, not at all, because I mean, the main intention was to protect those individuals and as well to protect the information from leaking. And the way we operated that time, normally when we subpoena a person, we expect the person to come to the public protector office.
Yes.
But in this instance, because we were investigating the president, the initial letter was delivered to the president where we had a meeting. The Section 7(9) was delivered to the president where we had to take him through the Section 7(9) and what we relied on to come to the conclusion. So it was purely to protect the integrity of the investigation. And I think you've also indicated that to Bianca and Mr. Matabuche that it means I was supposed to even convince them or push them in this so-called conspiracy. Yeah. It was purely that when we were investigating the matter.
Yes. And sorry to ask you this because it's at the risk of stating the obvious, as we say, but I think it was Mr. Matabuche who also indicated that you personally delivered the Section 7(9) letter to the president. Is that? Can you confirm that?
Definitely. Hence, I'm saying I had to go with the team.
Yes,
Normally, we just send a messenger or we email it. And that's all.
Yeah,
But in
you
this
don't,
instance,
yeah, okay. That's why I'm saying at the risk of stating the obvious. So you don't go around delivering section 7(9) letters. It was purely out of respect and protocol of the
definitely.
office involved.
Mm.
Okay, good. All right, then let's go to 286.
So most notably, it would be absurd to label as dishonest or biased a view or conclusion which was reached by the Chief Justice, who expressed the issues in even stronger terms. That view may or may not be correct, but it is certainly not reached in bad faith or outrageously, as alleged by Ms. Mazon or the evidence leaders.
All right,
When
let's
they were
just,
leading evidence, yes, because that was purely what we focused on. And I think this also reflected how the Chief Justice has gone through. Well, in the judgment, you could see that he read each and every document which we submitted.
yes, good. Thank you. And we'll get to the Chief Justice's remarks, but the point you're making there is that sometimes the Chief Justice expressed himself even in stronger terms than you did in your report about,
Definitely,
for example, rejecting the version of the president and so on.
definitely.
Okay.
And when
So-
you,
Sorry,
so
sir.
the reference to the Chief Justice is in relation to the minority judgment.
Yes, sorry,
Okay.
not only that, Chair, the minority judgment and the former Chief Justice. So we have to be correct, yeah. So, thank you, Chair, thank you. So, yes, again, we're just doing that for the record because I think everyone here knows what we're talking about. All right, thank you. Can you go to the next one?
During my oral testimony, I will specifically refer in more detail to the relevant passages found in both the majority and minority judgments to indicate the factual flaws identified by me and on the basis of which I'm in respectful disagreement with some of the key conclusions reached by the courts as compared to the referable reasoning in the minority judgment.
Yes, okay, that's, so, Chair, that's preferable reasoning. Okay,
It's supposed to be preferable.
preferable, yes.
Okay.
The first, oh, it's 1R here.
Thank you.
Right, 288 now, okay, so now, and Chair, the Chair will have to bear with us here. You, maybe to make it easier, I'll interchange some of the key passages. I'll ask you to read and some of them I'll read myself. But this is something that comes from the judgment itself. Maybe we could, yeah, let's go to 288.
Okay, the key findings of the majority judgment are summarized in paragraph 137 of the majority judgment as follows. So
All
it
right.
says,
Yeah, carry on.
the public protector, like all of us, is fallible and mistakes are to be expected in the course of the exercise of her powers. But what is troubling in this matter is the series of weighty errors, some of which defy any characterization of an innocent mistake. For example, giving the phrase willfully misleading the meaning of inadvertently misleading for it to fit established facts. She disregarded uncontroverted evidence to the effect that the president did not personally benefit from the CR17 donations and stated that on the evidence placed before her, he benefited personally. This finding was made when there was simply no evidence to the contrary, These are some of the disconcerting features of the impunged report.
All right. So the, again, it's just to take a cue from what the chair was indicating. So in fairness, this is the conclusion or summary of conclusions of the majority report, just so that it's clear that we acknowledge that and we know that it's the majority judgment and what have you. But that captures, in essence, the key issues about what is known as the weighty errors, the whole thing about the code of inadvertently and so on, and then the issue of the benefit or no benefit to the president, and then as a summary of what they call some of the disconcerting features of the impugned report. Okay, now 289.
Okay, yeah, well, still on this paragraph, hence we will still deal with the issues of the code, and which I say I respectfully do not agree with how they came to this conclusion.
Yeah.
When the president himself said when he was the deputy president, that he was conducting the dinners and everything for being the president of the country and the president of the ANC. So 289, while I acknowledge that legally speaking, the majority judgment is of course a reflection of the law as it stands, I'm of the view that this committee is still required to inquire into the veracity of the adverse pronouncements made against me and or the Office of the Public Protector.
Okay, all right. So that really reflects the debate that I was saying to the chair. We'll postpone to the legal arguments about. There's a view here, at least that goes around, that once you have a judgment, that's it. There's nothing you can inquire into it. Fortunately, that view is not shared by Professor Matoncel, because when it came to the judgments which said that she was biased, she had very choice words to say about the charges and the fact that these were just their opinions and so on. But be that as it may, as I say, we'll postpone that debate. Now we then go to having acknowledged the status of the majority judgment, we then go to the what you said is the preferable view, in your view at least, of the Chief Justice. Can you then read from 290?
By way of contrast, the Honorable Chief Justice came to the following different conclusions, which I am in full agreement. 290.1, which is paragraph 168. For this reason, whatever legal personality the president and his campaign managers may have chosen to clothe the repository of his campaign sponsorship or financial assistance with cannot detract from the naked truth that, Roman figure 1, he pleaded with potential sponsors to give money in and for his name CR17 campaign, which is Cyril Ramaphosa's campaign for the ANC presidency in 2017. Roman figure 2, he knew that the money that was being given and spent on his own ambitious campaign came from an agreed structure known as the CR17 campaign, to which he also contributed. 3, Roman figure 3, he personally benefited from the sponsorship that propelled his campaign to its logical conclusion. The presidency, which is the presidency of the ANC. So election or elevation to a position you desire is a benefit. And the benefit is personal because the targeted beneficiary gets to occupy and enjoy the position and all its accomplishments.
Accompaniments.
Accompaniments. Yabona ke, Queen's language.
Just,
Yes.
Mkhwebane is like that.
Yes. It is perhaps necessary to state the obvious. The position is not occupied by a group, but by an individual.
Mhm.
When the sponsored one attains the desired position, people congratulate him or her because they see him or her as the winner, the successful one.
Right. And when you say you agree with those sentiments in summary, maybe without going directly to the report to save time, I'll just ask you if that accords with your own conclusions on the topic.
Yes, it does, because remember the emails which were sent even directly by the president, the letter which he wrote to the speaker indicating or correcting and indicating that it's for his campaign. And then thirdly, the bank statements or the money flow, which was moving through the accounts. And I think there was a stage where even the president issued a statement where he said they will return that 500,000 back to Busasa. So all those were proof enough that this was an individual benefit.
All right. As I promised earlier, maybe I'll read the next one and then you can comment. Yeah. It's paragraph 171 to 90.2. Thank you. Yeah. Paragraph 171 of the judgment, Chairperson says, for this reason, any proposition that the public protector should not have investigated possible ethical breaches concerning all the CR17 campaign donations, either because Honorable Maimane MP did not explicitly mention the CR17 campaign or seems to have confined his complaint based on the donation to the relationship between African Global Operations or Mr. Watson and the president and his family, would be missing the point. The president himself said that Mr. Watson's donation was made to, quote, a campaign established to support my candidature for the presidency of the African National Congress, unquote. It was his campaign, and it was known as the CR17 campaign. It is such an embodiment of his aspirations that it even bore his initials. This was the one and only campaign structure to which donations to his presidential campaign were made. African Global Operations is a donor like all other donors to the CR17 campaign. The pursuit of the whole truth alluded to in Mail and Guardian demanded of the public protector, in obedience to the constitutional mandate of her office, to strengthen our democracy, to investigate and satisfy herself on behalf of the public, that none of the other CR17 campaign-related donations were on the wrong side of the constitutionally prescribed set of ethical standards. Firstly, is that in accordance with your findings?
Yes, it is in accordance with
Your findings.
my findings.
And what Justice Mahong referred to as constitutionally prescribed set of ethical standards, would that then refer to what you said just before lunch, including Section 96 and the Act and the Code?
Yes, that relates to that, and it's applicable to, well, that's the legal framework which we focused and relied upon.
Yes.
Mm.
Okay, you can read the next one.
The president's duty to disclose was triggered the moment he agreed to establish or became aware of the existence of the CR17 campaign, asked sponsors to support his campaign, and became aware that money was being spent by the CR17 campaign to advance his presidential bid. The emails in the possession of the public protector, which are, by the way, merely additional but not essential material for the purpose of establishing a case against the president, that are not denied, and the briefings to the president about the state and activities of the CR17 campaign make the situation even worse for the president. The contents of any genuine email generated by a specific person should ordinarily be as good as the oral evidence given by that person. As a matter of practice and law, the contents of an email or a document by X and Y may, assuming its authenticity is not disputed, be used to contradict and discredit their own oral evidence and vice versa. This extends to the evidence of the recipient of those emails who might have asserted a contrary view. He or she may be similarly discredited. For this reason, the public protector ought to be understood to be saying that the oral evidence of the president and the CR17 campaign managers regarding the happenings in the campaign with regard to the donors and their donations was effectively belied by their own exchange of emails that revealed that the president knew what they claimed in their oral evidence that he did not know. So I think, yeah.
Right, okay.
This, I think you mentioned earlier the question which was asked to Mr. Mataboge about the email, but it then reflected that he did indeed receive an email about the OIGI report, remember? So even here, the issue of the emails, it was never disputed. I think there will be a paragraph where we deal with the emails further in the judgment. Yeah.
Yeah, thank you. And maybe in this context, we should touch on the following issue. Because unlike Mr. Mataboge, who, as you correctly say, had to be reminded or confronted with his email, you don't have that luxury, because this committee decided that the president, the recipient or author of some of these emails, including the one authored by the president, should not be called here to go through the same exercise as Mr. Mataboge, where we could say, or you, through your lawyers, could say, but you say this, but here's the email, so that like Mr. Mataboge, maybe he could say, oh, well, yeah, now that you mention it, or explain it away or whatever. So what is the impact of that on what you read yesterday about the fairness of the process?
I think that doesn't give us an opportunity to also allow the president to inform the committee that indeed we met, indeed we involved him throughout the process, and the process was actually very fair, and it was conducted in a very respectable manner, and he was given an opportunity to respond to a Section 7(9). So, and the evidence we relied upon, which we also brought to his attention. So it was going to make the process as well to be fair.
Okay. Right. The next paragraph which you highlighted for the committee in your statement is at 290.4, Chairperson. It's paragraph 174, and it reads as follows. Besides, even in the absence of the proof emails uncovered by the public protector regarding the president's knowledge of who the donors were and what the CR17 campaign was doing, just how realistic or in keeping with the lived experience is it to assume that he would not want to know about the progression of his own destiny, his own destiny defining project, or that donors would not want him to know that they were his enablers to the much coveted position or throne. He should, with respect, not be allowed to hide behind a structure that bears his name and that was established for the primary purpose of advancing his private interests, and that actually advanced his personal mission to be president. Now, in relation to that particular passage, it seems that, of course, well, firstly, is that in keeping with your findings?
I think what is central here is that the president was saying he was not involved, he didn't know. But then it's very clear here that he was aware of the monies, he was being updated about the performance of the fundraising, and the fact that Mr. Watson confirmed that he attended some of the dinners. But then I think the emails were the ones which were clearly also showing that he was even approaching other donors. And hence I said in the article and others which will still share, it was the very same individuals which were approached to donate.
Okay, to 90.5. Thank you for that.
So whichever way you look at it, the president received a disclosable benefit, disclosable precisely because it has a potentially compromising short and long-term effect. That money could have and should have come directly to the president because he is the one who needed it for his own personal benefit. He was required to and should therefore have disclosed it. That he and others chose to set up a structure that had the presumably unintended but effective result of undermining or frustrating the imperative to be transparent, accountable, and to disclose to Parliament, to be ethical, cannot help him. It cannot help the president that he might have chosen not to know who his benefactors were. He knew and should have disclosed that the people or entities he addressed, asking them to fund his desire to become president, heeded his plea or call and gave money to the CR17 campaign, and that CR17 in turn released money for his personal election to the much sought after office of president of the ANC. So this one, that's where it also answers the question by, or the clarity by Honorable Mailham. But then I think possibly you'll still show or I think that will be right, will be shown to me, those paragraphs where the majority judgment is saying, well, this has nothing to do with well, it has to do with the campaigns for the presidency of the ANC. Therefore, the president was not supposed to disclose. The president is not a member of Parliament. But I think I've clarified, and I think it shows that Chief Justice Mkhwebane understood the report, because in the report, we are very clear that he was investigated as the deputy president. Yes. And he was the member of cabinet, member of Parliament. And that legislation, which we will read into the records, it is very clear that from 350 rands needs to be declared.
Yes. Okay. I think in fairness to the majority judgment, and I stand corrected, I'll check this. If I'm not mistaken, it was the majority judgment did not make that mistake that Mr. Malham was making, but I think that was in the High Court judgment.
Oh, okay. Oh, yes.
But we'll check that, just so that we don't we get the facts correct. Yeah. All right. Then and in an event, we'll talk about that High Court judgment in relation to when we talk about the code, because well, not only when we talk about the code, or when we talk about your power to refer something to the NPA,
Yes, yes.
because there was that contradiction. So we'll come to that. Yeah. All right. 90.6 says, yeah, paragraph 176, on the need to disclose, again, I say, the president knew of the CR17 campaign, which existed primarily for the purpose of advancing his political career. The veil sought to be erected between him and that project should not be allowed to obscure the truth or reality. He was more unlikely to have been ignorant of a matter so destiny-defining and all-important. He was therefore under the obligation to disclose, in the very least, his private interest in the form of the sum total of the money paid to and used by CR17 campaign. How this entity benefited him financially in his journey towards the presidency of the party. I'll talk to the next one. Do you want to comment on this, or should I can to the next one?
I think you can move to
Okay.
to the
You
next
can comment
one.
to both, yeah. More importantly, as the public protector correctly found, when he received or caused others to receive the sponsorship or financial benefit, he was still the deputy president of the Republic and the member of parliament, the point you were making. The code applied to him fully. He cannot be exempted from the consequences of what he did then by reason only of the fact that the quote personal benefit has worked so well that he now occupies the position of president in line with his and the sponsor's set objectives. I think you've just commented on this. This is the Honorable Malham point.
Yes, it's correct, and I think though the figures are not reflected here, but indeed the financial benefit which has been shown and how the monies were utilized.
Yes.
Mm.
Well, okay. Anyway, on the question of the figures, we know, well, at least the court, the committee and members of the public can take notice of the fact that the president, I think, had estimated the figures of his campaign to be about 300 million, correct?
I think it was he himself, when we were investigating, no, but I think I had it at the Zondo Commission when he was testifying.
Yes, and apart from that, putting aside whatever happened at the Zondo Commission in line with what we were saying, that we won't necessarily rely on anything that happened thereafter. It's your evidence in the report is that the campaign managers had put the figure at around even lower, 200 million, correct?
Yes, yes, I was coming to that unfortunately as well, they were also not well truthful, but on the other hand, they were estimating and they were saying they must still do the final auditing of that particular account. So that's what they said.
Yes.
But then when the calculations were made, that's the figures which are in the report, which we had to come up with. I mean, that 400 million, the 300, what 190, 191 or 388. So yeah, million.
Yes, the figures that we read before lunch come to over R1 billion.
Again, yeah, if you say, I didn't calculate.
Okay,
the
well,
budget,
okay,
yeah.
okay, there's 200.
It
I
was
mean,
190.
Yeah, let's say that's 200 rounded off, yeah.
Yes, and then there was 388,
Mhm.
and then there was 441, I think.
Mm.
Yes.
And 50 something. Anyway, it's fine. We don't need
And
the
300 and
sums.
something,
Let me
yeah.
just say it's far more than either 300 million or 200 million.
No, definitely. No,
Yeah,
it is.
okay. Thank you. All right. Now, then the next paragraph is 200. Sorry, I'm also thinking in millions now. It's 290.8.
Mm.
You can.
Yes.
Mm.
So the public protector should have afforded the president the opportunity to confront the contents of the emails that vitiate the version of the president and his campaign managers. It is concerning that she too, like the president, chose not to address the central feature of the concern raised. Why she did not hear the president's side of the story before she finally relied on the emails. That is what the audit principal demanded of her, but the president has taken us into his confidence and shared with us the views he would have expressed to the public protector regarding the emails. Had he been afforded the opportunity to do so?
Right. Okay. So in a nutshell, the Chief Justice was saying that they were criticizing you for the Audi. We know that whole story about the second Audi and all
Yes.
that.
Mm.
But you are saying that, well, whatever the president would have put in his second Audi, he has now put before the court.
Yes, correctly.
Right. Okay.
And I think, hence I said earlier that this information, we received it almost at the end of the investigation. But indeed, it's not an excuse that we should have then went ahead again, issue a second or supplementary section 79. And again, it goes back to the issue of the time frame to make sure that, we are not keeping the person or implicated person or a person complained against to be waiting for the outcome of the investigation. But so in other words, I do agree to this, and I think that's where we improve continuously.
Okay. So with the benefit of hindsight, you say that was fair criticism of you by the Chief Justice, also given the subsequent cases that have also found that remedial action should be included in the section 79, correct?
Yes, remedial action, but then as well, each and every information which we rely on.
Okay.
Yes.
Oh, I see. Even if new information
Yes.
arrives, you then still have to give Audi.
Yes.
Okay, good. All right. So 290.9.
And it
And I think,
bears
sorry,
out.
yes, this is where I think where you said the Chief Justice sometimes used even stronger language than the public protector in disagreeing with the president.
Yes.
Okay. 188.
And it bears repetition that false version is that there was a deliberate plan to ensure that the president does not get to know who the donors were, how much they donated, and how the financial assistance received for his campaign was being used. The emails squarely belied this assertion. The question that we should then be asking ourselves is, why did the president and his team deliberately convey a falsehood on an issue so crucial and inextricably connected to the constitutional imperative to promote and observe high ethical standards in obedience to the demands of our democratic state's founding values, which is openness and accountability? He must have known that if the truth evidenced by the emails were to be told, the obligation to disclose the names of the funders and the size of their contributions to the National Assembly, and by extension to the public, would automatically and plainly be triggered. And in terms of the essence of my vote counts, the public will then have the opportunity to curiously and vigilantly monitor the outward manifestation of his relationship with the sponsors in line with the concerns raised by Honorable Maimane MP regarding Mr. Watson and the state tenders.
Okay, comment?
Yes, I think it goes back to besides what is indicated here. That was the intention, that at least for compliance, the National Assembly in terms of Section 55 of the Constitution, or members of Parliament, their role is to conduct oversight and to hold the executive to account. So the issue of them declaring and as well indicating what contributions and what resources they have, I mean, it's within the issues. Again, it goes back to the values of the Constitution. And again, going back to the fact that anyone who would want to be the president should be an embodiment of the Constitution. I mean, believe on the principles of accountability or on the principles of openness and transparency.
All right, thank you. Chairperson, you'll be pleased to know that we're going to the last two of these extracts. The other one you highlighted for the committee is 290.10. And it reads as follows. It's paragraph 192 of the judgment. It also bears repetition that the president carefully and intentionally gave a false version of what he knew to be the case to the public protector. What he did is highly unethical and a resounding rejection or dereliction of his key constitutional obligations. This is therefore not a question of the president and his team mistakenly putting forward a version, such as he did in the National Assembly with regard to the alleged Busasa donation to his son, which he subsequently corrected. It is rather a case of a calculated misrepresentation of the facts by someone who is confident that the truth would never be uncovered. No wonder the president and his team have made no attempt at reconciling their version with the emails. The two versions are mutually exclusive or destructive and obviously incapable of reconciliation. And all the president could do and did was to keep on asking the public protector, and I paraphrase, how did you manage to access this well-kept or closely guarded secret? Who gave you this painful truth? Who gave this painful truth to you? Says the Chief Justice. Any comment?
I think, as I commented before, that again, it goes back to the issue of when we conduct our investigations, we give the implicated parties an opportunity to give us their side of the story. And I think here we were not given all the information, because if we were given all the information, we would have even known that, or the president would have said he knew about some of the donors, but he just didn't want to agree or acknowledge at all.
Yes. And maybe then I'll read the last one and ask you to comment, because this relates to, again, a topic that's broader than just the CR17 matter. And that is about, you remember the debate or the, yes, well, I don't know if it was a debate, the discussion that Advocate Bauer and I had this morning about the Commissioner for SARS case, where in the Mazoni motion, it's cited as an example of your vilification from the bench, as it were. But in the Constitutional Court actually, for lack of a better word, rubbished those remarks and or disproved them. Maybe it's a more neutral term. So that's that was based on what the Matlanga J had said, that is a tendency of the courts to just target you for unnecessary criticism. Right. All right.
Yes.
So in that context, then this is what the Chief Justice said, and he, in typical fashion, used another bombastic word. He called it the magnification of the public protector's errors. And this is what he said at 199, which is the last extract. There is indeed a disturbing tendency by some of us to, presumably without intending undue harm or injustice, unduly magnify virtually every error of the public protector, real or mistakenly perceived. This is quite surprising because judges with more experience as practitioners before their elevation to the bench, and with more years of service as judges than the 10 years minimum requirement as an advocate, or the mere fact of being a judge, regardless of how long to be appointed as public protector, have committed similar or more serious errors, and we are not as harsh on them, or should I say on ourselves, and rightly so. Comment?
I think this goes to the core of the complaint or the charges. And I think it summarizes what you've been saying to correct the issue of, or as well pleading with members of the committee to understand that yes, there are judgments, but then as well, those judgments might have been reached using or through wrong facts. So hence, this process is an opportunity to deal with those factual issues, because yes, there's nothing we can do about them. That's why when we address the issue of the code, I'll show what I tried to do, irrespective of what transpired. And I think since you said it yourself that the former public protector also commented about the judgment of Borderell. But besides, I mean, one could
sorry,
check, yes.
I'm again taking over the position of the chair. You mean the judgment of Judge, Her Ladyship Justice Borderell?
Yes.
Yeah, okay.
Yes, I think that she's the one who decided that NEF, is it NEF or SABC? method,
SABC.
which you put
The-
through.
yes, the one that had scathing remarks against Professor Madonsela and called her biased, and that her findings were that the judge was dumbfounded, and it was astonishing and astounding, and not with an open mind. Yes, it was the SABC judgment. Yeah.
Yes, and I mean, if Chief Justice is also saying this about the judges, indeed, there were several judgments ourselves as an office which we had to go through, where higher courts were criticizing the lower courts judges. And there was no stage where those lower courts were then exposed or subjected to this particular process, which I'm subjected to.
Which process is that?
The process of coming here and be told that I'm incompetent. And yes, I do not know the law.
Yeah. All right. Just sorry, I'm just about to break my promise to the chairman.
I think you said you'll argue that during the legal arguments, because we wanted to include it in the statement, but then you said you'll also deal with it when you
Yes.
argue on the issue of section
Yes, no,
160.
certainly we'll do that. But I just wanted to read another, the last, something connected to the point you're making now, which also comes to the, or rather, which comes from that judgment.
And even the majority judgment, they also agreed that they are fallible as judges.
Yes.
I don't know whether you are looking for that. Or you are looking for their judgment.
Yes. Okay, this touches on the topic that I said we're going to pack, which is the issue of the code. Yeah. So, Chair, I'm sorry to do this, but if I just for the sake of completion, so that we don't go back to this judgment, I'm just going to read out paragraph 201. It's not quoted there. Of the Mkhwebane CJ judgment. It says, and it relates to, I'm doing it because it relates to the issue that Advocate Bauer and I were talking about regarding the Commissioner for SARS judgment. This is what Mkhwebane CJ says, quote, at 201, without any basis in fact or law. I'm sorry, Chair. I need to contextualize this again. This is the judgment I spoke about in the morning, Chair, where I said Ms. Mazzoni based her motion on the judgment of Mabuza J, which was in the High Court, but the Constitutional Court then reversed it. And I said, we're not going to make an issue about that, but obviously we have to point out the fact that the Constitutional Court then came to a different decision. So Ms. Mazzoni wrongly relied on the previous judgment. Obviously, she didn't know at that stage that it was going to be reversed. But the point that the Chief Justice makes is this. Without any basis in fact or law, Mabuza J concluded in Commissioner South African Revenue Service versus Public Protector that the Public Protector had, quote, a proclivity to operate out of the bounds of the law, unquote, and a, quote, deep-rooted recalcitrance to accepting advice from senior and junior counsel. And this was cited as proof of her unreasonable, arbitrary, and malafide conduct. He went on to order punitive costs against her in her personal capacity, a shocking and most unjust decision under those circumstances. Similarly, in Kabinde, this court held that 2 of its members had erred. What all of this means is that the manner and extent to which judges and magistrates criticize litigants, legal practitioners, and witnesses should be a mirror image of the same measure of criticism they would find acceptable under comparable circumstances, were it to be meted out to them by their colleagues, the practitioners, or the public. We must therefore do to others as we would have them or have others do to us. And so the part that I was saying we will raise in argument is that just as judges and magistrates have a duty to give out criticism which they would accept, we will hope that members of parliament also have the same obligation to mete out only criticism which they would take when the shoe is on the other foot. But that was just to connect with the issue that we raised in the morning. I don't know if you want to comment.
Yes, isn't it? This is a complaint which was lodged by Honorable Mazone, which was adopted by members of parliament.
Mm.
So, and it was based on the judgments. I
Mm.
mean, we can say 90% of the charges are based on the comments.
Mm.
I don't want to use the Latin word because you'll tell me it's difficult.
Yeah,
Yes.
no, I think
Mm.
we've had
So I
enough
think,
of that.
yeah, so I think it's very much relevant because this process also helps to us or me as well to, or whoever who is willing to listen
Mm.
to understand that this is how this matter was investigated, what evidence we relied on, and there were no sinister or conspiracies. But also it shows coming from the judge and the Chief Justice of that matter, that they also made mistakes, but also the issue of do unto others as you would want it to be done to you. So I think that's very critical, and I think it's something which others would want to see justice done, and as well for the justice system not to be utilized for ulterior motives or to destroy individuals or people. To understand that, I think let's focus on the law and what the law is saying and the facts. Yeah.
Yes. And yes, now, I mean, again, I don't want to delve into the closing arguments now, but I just want to maybe to comment. Let's assume, because you've also been accused of something called quote unquote reckless litigation. In other words, you were not supposed to go to court. Now let's assume in relation to that case of where Ms. Mazone is now seeking for that case to be used for your impeachment, where you were accused of all these horrible things, deep-rooted recalcitrance of accepting advice, proclivity to operate outside of the the bounds of the law, which Chief Justice Moshong says is shocking and unjust. Let's assume you had, in order to not to be accused of reckless litigation, not decided to appeal this matter to the Constitutional Court. Then this would have been the last word. And then it would have been justifiably used for your impeachment. Do you have any comment on that?
Thank you for that question, Chairperson. Hence, this, I must indicate that this process, it has never been easy. I mean, you said it yourself that I've been sitting there for 6, 8, 9 months, listening to all this and the judgments and the comments, and as well the accusations of wasting state resources or always going to court, or how much has been spent by the office on that. And the main aim for the office to oppose matters, because if you can check a lot of matters which we were taken to court on, I think SC is still going to take us through the achievements, the public protector in statistics and whatever, where you'll see that out of all the litigation or the matters which were taken to court, we were taken to court by the very same powerful and who have deep pockets. And by defending those matters as the public protector, it was purely to make sure that we defend the poor. And because these reports we issue to the benefit of the poor and the marginalized, but as well contributing to clean governance. Secondly, when we defend those reports, it's because we're checking the issue of the mandate of the institution, whether if we allow the court to come to a certain judgment it will impact on the mandate of the institution. I think, secondly, there is a duty on us as, well, if you are legally qualified and you understand, or as a officer of the court, that you need to assist the court. Sometimes you might not even want to only file a explanatory affidavit, but you'd want to oppose whatever the other party would want to achieve. And I think there was then a tendency where every official will then litigate and use the very same state resources and even one personal costs, which were going to the heart of threatening me as, or instilling fear, because when you then attack a person financially, then is instilling fear. So I think, hence taking this to the Supreme Court of Appeal, to the Constitutional Court, was to make sure that let there be direction, let also be clarity on a number of issues. So I'm glad that we took this matter up to the Constitutional Court so that this issue can be clearly dealt with. And also, if just Judge Mabuse listened and is seeing that, it's part of his history to know that going forward, this is what he should also be considering. But again, I am always doing this and sitting here in this excruciating, painful process because it's for the benefit of history. I mean, if you'd know, Nyatela used to say, I said, it's not for us, it's for our generations to come. And whether history will judge us correctly, the very same justices and the records do not lie. So I'm glad that I did that. And I would encourage a number of people, if you can, let's make sure that you have that right within the Constitution to escalate and take matters to higher courts where possible. And I think there was one investigation we did as an office, but we'll deal with it some other time, where the minister didn't take the matter forward or appeal that judgment. And unfortunately, that was the final judgment. And when the complaint was lodged by the DA against that minister, that's all we could rely on, because even if he says, no, I didn't lie, but here's the judgment. And we've seen that sometimes factual errors can be made and the courts will come to a very wrong judgment. So at least the higher court or another court might come to a different conclusion. But unfortunately, sometimes they also confirm the wrong facts. I mean, issues of Bofriede, which we're still going to deal with, issues of those notes which were written by Kekan, which are blamed on me, but we're still coming to those.
Yes. No, thank you very much. And just for, in case anyone has forgotten, that those are the words that you've just referred to were uttered here on that seat where you're sitting by Mr. Nyatela, who said that those were words that came from you, which he will take to the grave, where you said, Mr. Nyatela, it's not about you, it's about the future of our children and the future of the Black child and those not yet born. All right. Well,
on that, maybe we'll take a break
okay,
for 10 minutes.
Chairperson, can I plead with you just to give me 5 minutes? I just want to round off this topic. But please, please.
5 minutes now or when you come back.
Pardon? Okay, we can do. I can do.
Okay, it's fine. Take the 5 minutes.
No, yeah. I just no, it's fine. Chair.
No, let's do it. Let's do it.
Okay.
Let's do it. Let's do it. It's just a few minutes. Let's do it.
Chairperson.
Thank you.
Okay.
Yeah, we'll fill up the bottle after the 5 minutes.
No, it's fine. So, Chair, let's.
I can't. Yeah, I need to.
Chair, you win.
Thank you. We'll take a tea break back at 20.
Recording stopped.
Welcome back, colleagues, from a short tea. We proceed immediately. You can start with your 5 minutes that the public protector denied you.
Thank you, Chairperson. I think the public protector looks like a new counsel. Right. Yes, thank you, Chair. I just wanted, the reason why I wanted us to do it before tea was because it was just flowing from the evidence you've just given. But excuse me, it's just two quick points. You've made the point that had you not appealed the judgment of Busisiwe, which made all those scathing remarks against you, it might well have been used as a basis for your impeachment on the theory that it's a judgment and therefore it must just be rubber stamped.
That is correct.
Right. But anyway, that theory will be tested in due course and at the appropriate time. But the first of the two things I wanted to say in relation to that is you remember, and you can comment that ironically, Professor Madonsela, when confronted with the scathing remarks of Justice Potter, her answer was exactly that had the matter been appealed, then maybe it could have been different. So again, showing the importance of why it is that sometimes matters should be, or rather that we shouldn't just take judgments at face value. Any comment?
You know, on the issue of, I know we're still going to deal with the evidence of each and every witness. And it's true what you're saying and what Ms. Madonsela said about the appealing the judgment. Because I think through her evidence, which we're still going to deal with, it was as if, why didn't I appeal the judgment? Or it's as if I wanted just to put her through that process. But again, I think you interviewed or you cross-examined one of the witnesses where you were saying, again, I said it yesterday, what if the public protector was also under pressure or was trying to make sure that she also is seen or is doing her job without fear of favor. By then there was a lot of, well, since I started in 2017, 2016, 2017 was the worst, especially after the CX report. And when I was taken to court, already the media and everywhere, the issue of the findings against the public protector by the courts. So if you check those judgments, they were issued during those times as well. And there was that rethinking, sitting with the leadership and checking which judgments must we not oppose, which judgments must we not appeal. And I must indicate that there were a number of them which we appealed, hence the Home Affairs matter, Public Protector versus Home Affairs, which was appealed to the SCA. And the SCA gave direction on the powers of the public protector, whether they are subjected to budget or the principle of legality. So I must say that, you know, sometimes you find yourself having to balance various issues. And indeed, taking the matter on appeal doesn't mean you are wasting or you are litigating recklessly, but you are in a mission to make sure that you are assisted sometimes with the interpretation of certain provisions of the law and the Constitution.
Thank you. And then the second point then that I wanted to make before tea was also in the context of, and it's not the first time I read this out, but in the context of the remarks that were made by Justice Mkhwebane in relation to the fact that judges, the public protector should be charged according to the same standards, as it were, as judges. Obviously, doesn't mean that the public protector is a judge, but in the context of being able to give criticism that you are prepared to take yourself. So that before the chair can remind me that it was a minority judgment. I want to read the remarks of the same sentiment which was expressed in the majority judgment. When the Constitutional Court unanimously reversed Busisiwe's scathing attack on you. And this was quoted with approval by Mkhwebane in the same judgment at paragraph 198. And in my respectful submission, Chair, this really, again, as the public protector says, almost encapsulates what this whole business is about, or what it should not be about. He says at paragraph 198, the following wisdom-laden words of caution by Madlanga J encapsulate the concern I have about the treatment of matters involving the public protector, Advocate Busisiwe Mkhwebane, particularly her findings and recommendations or remedial steps. Although the context was different, the message or principle is just as opposite and telling in all other cases. And then he quotes the unanimous judgment of the Constitutional Court in the case that we did when we challenged Busisiwe's judgment. And that's where Madlanga J had said, and I quote, almost identical to the cautionary that was issued by Justice Mkhwebane. He says, there appears to be a developing trend of seeking personal cost orders in most, if not all, matters involving the public protector. Courts must be wary not to fall into the trap of thinking that the public protector is fair game for automatic personal cost or awards, whether inadvertently or otherwise. And I think that those are the most important words. I'll come back to them. Whether inadvertently or otherwise, the High Court judgment in EFF Godan matter and in the instant matter, that's the Mabuza matter, are instances where the High Court fell into that trap. Then he says, I voice those words of caution because of the disturbing frequency and regularity of applications for and awards of personal cost orders against the public protector. What is particularly disturbing is that it is clear that the applications and the awards are not always justified. So from the Chief Justice calling that judgment shocking and unjust, to the warning now by Madlanga J for the majority about how you get targeted unfairly sometimes for this special treatment, let's call it. And I want you to comment on this because I think in that whole passage, the most important words are whether inadvertently or otherwise. That's, for me, as a lawyer, I think is probably the most serious indictment one can pass on to any court or even any judiciary. Because it suggests that your targeting might be inadvertent. In other words, it could just be misfortune or otherwise. And otherwise can only mean it is intentional. And I don't even want, it's what a certain PW board has said, it's too ghastly to contemplate. That if that even as a possibility. Yeah. But anyway, the Constitutional Court then said that the High Court had allowed itself to fall into the trap of singling you out for special treatment. And as I say, as a lawyer, I've never heard of a situation, and I hope if it has happened, it never happens again, where there is a particular litigant who is treated as a special target for certain treatment. What is your comment on that?
Maybe just before you, it's such a long point you made. I don't know what you wanted to comment on. I hope I'll comment.
Yes, no, Chair. Okay.
PW board.
No, I'll break it down. Thank you, Chair. I'll break it down. Okay, putting aside the PW board,
the judgment. Yeah.
Yes, I was linking it. No, the Chair is right, because in that summary there were different concepts. The point is that linking this comment of the majority now of the Constitutional Court to the earlier one that I read out to you, particularly in relation to the hopefully inadvertent targeting by certain courts. What is your comment?
I would say this also reflects to the public that going back to touching the untouchables, because there were comments which were made by one retired judge, which I'll have to get that article or recording so that people can understand that I'm not just making that up, where he said I should be bankrupted. And meaning that possibly because the process is difficult to remove the public protector, then use this painful process to deal with me. And indeed, I'm also fallible. I'm not saying I'm perfect, and I also make mistakes. So if my mistakes are then magnified, like what I'm glad that Justice Madlanga had to comment the way he commented, and thanks to also having a legal representation like yourself, who'd also reflect and show the courts that, making mistakes, and I think we will still deal with the CX judgment. Again, the Chief Justice then, Mkhwebane, was reflected on how he went through our documents and applied everything which we said. And I think that's what objectivity means. But as well, giving the requirements for issuing judgments where you subject people to personal costs. In issues of dishonesty, issues of misleading the court. And again, if that is intentional and it's also reflected, but if one is making mistakes, then being subjected to this, and indeed, they're saying magnifying this, but for me, I felt it was fashionable for, judges, especially in the Gauteng North High Court, where any person who just asks for personal cost against me, then they would be granted that. And unfortunately, based on wrong facts, that happened with even the Freedom matter, where the judge told me he had to reserve or wait for the Constitutional Court to decide on the personal costs issue. And then she also had it decision where she said, I need to pay personal costs. So that also is for history to judge all of us, because if you have precedents like this, and we have a situation where public servants, and especially a head of a Chapter 9 institution, will then be scared to do their work because they'll be subjected to personal costs. So, and where would you get that money? Or again, that will cause you to be scared to take decisions and to be a lackey of any other person, because then you won't be investigating without fear or favor, because then you'll be investigating having fear at the back of
lead this nation. Strategically and intentionally giving a false version to the public protector while she is investigating a possible ethical breach falls squarely within the catchment area of this section. And then he says, truth or integrity is, after all, at the heart of the office of the President of the Republic, particularly in relation to his or her constitutional obligations. Deciding to present a version known to be untrue, to be an organ of state, whose constitutional duty is to strengthen our democracy, is conduct that is inconsistent with that high office and the obligations that the incumbent has to uphold, defend, and respect the Constitution. And so is the failure to report sponsorship of financial assistance from the donors he has addressed and asked to donate to the CR17 campaign. This violation would still be established even if this obligation to tell the truth and disclose is confined only to the money from his campaign, which is, after all, neither his political party nor an official structure of his party. The second leg of section 96(2) has already been dealt with at some length, and I will thus say no more. Lest we forget, we are not dealing here with an average citizen, but with a bearer of specific and frighteningly weighty constitutional responsibilities, who is expected and required to lead by example and be above reproach. His office demands of him to be the lighthouse, the pathfinder, the embodiment of and vessel for the enforcement of high ethical standards, particularly the foundational values of our democratic state. In this instance, transparency, accountability, and the supremacy of the Constitution. Like all of us, he has rights, but unlike all of us, he does have special obligations, not imposed by courts, but by the Constitution and legislation. It is the President, the number one or first citizen of the Republic, who we are talking about here. His is a distinctive and supreme office in the land that does not permit the employment of extraordinary technicalities when issues of ethics, transparency, accountability, upholding, and respecting the Constitution have to be considered and pronounced upon. It is in this context that one is constrained to keep on saying that technicalities must not be allowed to easily frustrate the fulfillment of core constitutional obligations and the attainment of substantive justice. And I need you to comment on two things. One, I think you've already commented on the issue of the special status of the president, but particularly what is being referred to here as, instead of addressing this question, where did the money come from? Who are these people? What do they want and all that? Going into technicalities as to whether the public protector has jurisdiction and what is the definition of personal gain and what have you, where did the emails come from? What do you regard that as conduct that was consistent with what is said here?
It's not consistent at all. I think also I've mentioned in paragraph 296 of my statement that
Sorry, 296.
96, yes, where I said the president's technical approach in this matter leaves much to be desired, because especially when he says he stands for ethical leadership.
Sorry, maybe let's put it up.
Mm.
Statement 296 paragraph page 630. Oh, is that okay? Sorry.
Yes. So yeah, 296, where I was also speaking about the president's technical approach in this matter leaves much to be desired, especially when he says he stands for ethical leadership, but goes on to avoid accountability by ensuring that the CR17 campaign existed independently. However, he does not argue that it registered as a separate entity. So it was his campaign and he was the face of the campaign. So I think the focus indeed was on that, and I think we're still going to take. We're still going to address them in the statement, because like the issues of the code, the issues of it was for the ANC campaign. So it means that that was also perpetuated by the media, mainstream media, and they only made sure that people focus on all those. And the mistakes which were there, or genuine mistakes which were there, but the fact of the matter, they didn't report about what is his understanding as the deputy president, that is Executive Members Ethics Act applicable to him, and did he act accordingly? Whereas still, I think the issue of in the Nkandla judgment, I think the same judgment of Mkhwebane, where he said the president is a constitutional being. And then being a constitutional being, again, you take an oath of office in terms of Section 95 of the Constitution, that you will abide by the Constitution. So I think the intention of the public protector in assisting that the country should have good governance, clean governance, but as well ethical leadership. The focus should be on what has happened, what should have happened, because the should have happened part of it, we are testing it against the available legislative prescripts. So in this instance, we had to check what Section 96 of the Constitution is saying, what the Executive Members Ethics Act is saying about his conduct. But unfortunately, I know there are instances where I even said sometimes the court judgments focused on technicalities, but they fail to address the issue of is what we are doing as the courts assisting in the achievement of justice. Because I can go on and just indicate that some of the judgments, like the vendor pension fund matter, you find that it was purely on technicalities, but the fact of the matter is, are those vendor pensioners, what impact and the implication of the decision makers had on them? So it was justice served as far as that matter is concerned. No, it was not served. But again, that is reflecting what those who are in the executive, who have the financial muscle, who have the resources, can go to courts. And I think courts should be learning from such instances that sometimes, let's put aside the technicalities and the best lawyers you are having, the implications of their judgments to the future of clean governance of the country, or the implications of their judgments to those poor and the marginalized. And the nice thing about the public protector is that people who don't have the money, the resources, they would use our offices because they don't pay. And at least as an office, we are able to sometimes defend them and escalate the matters to court and assist the court. So I think that's the best ever we are doing for this institution, or for the public, actually. But unfortunately, then the motion is saying we're litigating recklessly, forgetting that that is done with the intention of making sure that we protect those who cannot litigate, those who don't have the resources and the money. So this institution, as Mkhwebane said, that it's like a biblical David, which the public is to represent them and to take matters up, because you will not find people going to court. It's very expensive.
Yes. Thank you. Okay, thank you. Then maybe to round off that entire topic, can you read 297?
So
Sorry. Yeah.
he then goes further to adopt a very narrow approach and say that he did not personally benefit from the CR17 campaign, but on the facts it is through this campaign that his personal status from being an ordinary man to becoming a president of the country changed. To date, the CR bank statements remain sealed. The country does not know who provided funds for the CR17 campaign. This is in contradiction and in violation of the constitutional principles of openness and transparency. To a greater extent, ethical leadership, which the president and his followers claim to adhere to. I think again here it's a question of leading by example, being a constitutional being. And if we have this constitution and we have to have the constitution as a living document, where we need to see every leader acting accordingly.
All right. No, thanks.
But I think 298, we dealt with section 96. Because
Yes, we'll
here,
tap that.
again, I was still emphasizing to everyone out there that we dealt with this investigation as in the capacity as the deputy president of the country. And we were saying, and even any person who intend to be an executive and the minister, and I said it yesterday, that when we train, engage MECs, but then we never had an opportunity where we can have all the members of cabinet, of the ministers together, because that's our intention to say, these are the things you need to avoid. Because again, when I go around, I used to say, we are tired. We don't want to receive complaints about you, but these are the areas you need to stay away from. And it's so unfortunate that section 96, the test is very minimal. It says you must not expose yourself. Doesn't say you must have a conflict. So it says you must not expose yourself to a situation involving the risk of a conflict between your official responsibilities and your private interest. Which is clearly stated in section 96 of the Constitution.
Okay, thank you. And I think, okay, in the interest of fairness, also even to the president, in the previous paragraph where you say he moved from being an ordinary man to becoming a president, we also need to acknowledge that he moved from being a deputy president to becoming a president. Not like from the taxi rank.
Yes.
Okay. All right. So Chair, I just wanted to, I hope I'm right about this paragraph. Yes. Okay, just a cross reference to the idea that you've just said now about the meaning of the conflict and the risk and all that. Chair, if I can refer the committee to the Nkandla judgment. I had a key of, yes, bundle C, I've got it here. Item. Bundle C, item 4. Not the list. Oh, paragraph, it's just one sentence at the end of paragraph 9. That's just the order, the paragraph 9 of the judgment itself, yeah. For the yes, I just want to emphasize this. The office of the president is just anybody. You or anyone else could be the president, hopefully. So this is what I think was said by the Constitutional Court about another president. And I just wanted to check if, to the extent that it applies to any president, then whether it captures what you've just said about the risk, or rather the breach of section 96(2). Remember, we've had this, at least the most high profile cases in this country regarding breaches or alleged breaches of section 96(2) would be in Nkandla, CR 17, and Palapala.
That's correct.
Yes. So this is then what the Constitutional Court said. There is thus a direct connection between the position of president and the reasonably foreseeable ease with which the specified non-security features, asked for or not, were installed at the private residence. This naturally extends to the undue enrichment. Also, the mere fact that the mere fact of the president allowing non-security features about whose construction he was reportedly aware to be built at his private residence at government expense expose him to, quote, a situation involving the risk of a conflict between his official responsibilities and private interests. The potential conflict lies here. On the one hand, the president has a duty to ensure that state resources are used only for the advancement of state interests. On the other hand, there is a real risk of him closing an eye to possible wastage if he is likely to derive personal benefit from the indifference. And the last sentence is the one that's often quoted to define section 96. And I think it was also quoted in the independent panel report on Palapal.
Mm.
And it says, to find oneself on the wrong side of section 96, all that needs to be proven is a risk. It does not even have to materialize. And that's really the question I want to put to you in relation to everything you've said on the CR 17 Busasa matter. And I wanted to comment on whether there was a risk, not necessarily one that materializes, the risk of this kind of conflict. In fact, maybe let me put it like this. If there was no risk of breaching the law, why would the CR 17 managers have kept away, according to them, the information, the identity of the donors? If there was no risk, why would they do that? Wouldn't that be itself an acknowledgement that there was a risk of a conflict?
I think commenting on that paragraph, and especially linking it to the Busasa judgment, I think if you can show it again, Tsepo, because if you check even the footnotes, it's very critical for you to just note that so that when we deal with that issue of the code, we can deal with the issue. Indeed, the footnote, the previous page. Yeah. So, but then before I deal with it, if you can just leave it at that.
Yes.
The risk, indeed, it doesn't have to materialize. And I think that's what, if you read the report and the interviews we conducted with Abodone, Mutlatsi, and Chauke, it was very clear that they were saying no. And the questions which we were asking them was the president involved? And they were saying, no, he was not. Actually, we wanted him not to know who are the donors. And they even said, we inform those people that they mustn't expect any favors. all three of them were saying that. Though also during our engagements with them, the question was, but if you organize dinners, which we've shared the audio of our meetings, how do you then prevent that from happening? Because the president attended those functions or dinners, and the intention was to raise funds with those donors. So I think themselves, they were also taking precautions, but taking precautions which they knew that there's cases like the Nkandla, a judgment which is there and it's by the highest court, apex court in the land. I think SC and Chairperson, the most important thing is that unfortunately, if we are a country which, if we have judgments like this, which we need to learn from, but unfortunately there was a repeat in the Busasa matter. So I would say sometimes leaders or people who are members of parliament who would want to be leaders or ministers or MECs, and that's what was happening throughout our road shows of engaging members of the executive. Honestly, find it in your heart to learn, and honestly find it in your heart to be a true leader and a servant of the people, because once you do that, you won't have difficulty in complying with things like this. So that paragraph, well, Sepo, when you remove it, you could see that in the judgment, they are referring to the 2007.
No, let's go.
Code,
We must
yeah.
go to it. Yeah, thank
Yeah.
you.
So
Sir, before
yes,
you,
I just wanted to just say, we can note it, we can deal with it later, so
Yes.
that she will know when we say she must go to that paragraph again.
yes, thank you. Yes, and yes, no, that's what I was saying, because that's an important topic which we will deal with, I think, next after this. But just so that we don't mix up the topics,
Okay.
the comment, the question really I was asking you is the relationship between the alleged hiding of the identity of the donors and the in the same breath saying there was no risk of a conflict. Is that reconcilable?
It's not, because we're not saying even that risk materialized or that conflict materialized. But the fact of the matter is Section 96 is very clear. Don't expose yourself to that. Because yes, they knew that it's not a good thing to do. But unfortunately, again, they were not transparent enough.
Yeah.
Mm.
Yes. So even if the version was to be believed that they kept the thing away from the president, that in itself would mean that they knew that there was a risk of a conflict.
Definitely.
Right. Now, when we come to the, okay, I have a long topic and a short one. Chair, I'm in your hands. Which one should I do?
You can do both.
I can't. That's why I'm asking.
Okay, do the long one.
Okay. Thanks. All right. Then. Okay, I should not have asked that question. Let me follow the chair's direction. All right. Let's at least start with it. If it's not long enough, or rather, if it's too long, then we will we'll leave it. I just didn't want to leave it hanging, Chair. The issue is about, while we're on the same vein about judgments and the fallibility of all human beings, including judges, and the fact that judges themselves may make mistakes. And as I said, hopefully honest mistakes and inadvertent ones. I just wanted to remark, to show you the topic I want to deal with is, you remember one of your remedial actions that was criticized was the fact that you directed or gave remedial action in respect of the NDPP pertaining to the allegations of money laundering or suspicion of money laundering as expressed by Mr. Mkhwebane in relation to the CR17 funds.
Yes.
And if I remember well, and I'm paraphrasing, the nub of that complaint was that it's what we call in criminal law round tripping. That what Mr. Mkhwebane was alleging was that the money has just gone through so many hands and structures and so on that there was a suspicion of money laundering. I don't think he put it higher than that. In other words, if I just wanted to give money to the chairperson, yeah, once I start giving it to this one, we must give it to this one via that one, and then to Tim Ngosi, and then that one and that one. That's already, instead of just giving it to him. That was the type of allegations Mr. Mkhwebane was making. I'm not saying it was true, but was that what he was alleging?
Yes, maybe you can go to that letter in the report.
Yes,
Yes.
the complaint letter.
Look, we attached it in the report.
Yes, it is. It is. Yeah.
Yes.
I'm just checking
Because
which letter.
actually we considered exactly what the complainant was saying.
Right.
So even if we never met with him, as I said, in service standards, sometimes or most of the times we meet with the complainants, but such high level matters, sometimes we'll just call to clarify. Sometimes when the complaint is clearer, then we'll just continue to investigate. I think it's page 7 and 8 of the report.
Getting into trouble with my daughter now. But that's fine.
In your hands.
No, thank you, Chair. Let's just round it off. I've already defied you. I took the shorter topic. Right. Okay. Yes, Mr. Mkhwebane's letter is to be found at page 7. Yes, that's the one.
Since 7 years.
Yeah. Okay. It's a bit. I think
So he dealt with the
part-
improper relationship.
Mhm.
And then I think paragraph 1, 2, 3, 4 from the bottom, you see, yeah, counting even those sentences. It is my concern that the set of facts related above reveal that there is possibly an improper relationship existing between the president and his family on the one hand, and the company African Global Operations, formerly Busisiwe, on the other side. The nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises the suspicion of money laundering. The alleged donor is further widely reported to have received billions of rands in state tenders, often in irregular fashion. So that's where this matter comes from. And again, going through the mail and guardian thinking, because we'll have to just then deal with all the allegations which are mentioned. We cannot just choose to focus only on this 500,000 and forget about all other issues which were were raised.
Yes, okay, so to round off then very quickly so that we leave it at a specific point. You're saying that Mr. Mkhwebane's complaint apropos the money laundering was then based on what for short I call his allegation. It's not elevated to higher than that. His allegation of round tripping the money.
Correct.
Right. Okay. And the Mail and Guardian article that we will upload, if it's not uploaded, or we will refer to next, then refers to the other money. In other words, not just the 500,000, but the rest of the more than 1 billion or whatever the total amount is, we'll calculate it.
The other money.
The
Maybe
rest
let's
of the
say
money,
that,
yeah,
yes.
let's just call it that, yeah, for shorthand, yeah. Okay, and Mr. Mkhwebane, we have indicated to the committee, has indicated his willingness to come and testify to this committee to give his perspective, among others, on this matter. And we also remember that Mr. Mkhwebane was also, well, I don't know if he was a complainant, but he was a player in the freedom matter.
Yes, actually, the complaint was lodged by a member of the DA in the first
Mr.
stage.
Jankelovitz or something, yes.
Jankos.
Oh,
yeah.
But Mr. Mkhwebane was involved.
Yes, as an overseer. I
Yes.
don't know how their structure is. Yes.
He's not in the structure anymore.
Okay, by then, whether a national person at the head can, yeah, but he came with the beneficiaries to the public protector.
Okay,
Yeah.
good. Well, all right. So then Mr. Mkhwebane will explain for himself those issues. All right. Now, okay, now I'm committing suicide here because I had negotiated something with the chair, but I need to round off this this point. Again, maybe this is a point we will develop when we round this topic up. But I just don't want to leave it hanging because it fits in with the evidence you've given about judgments and so on. We were talking about this NPA on referral of the money laundering allegations to the NPA or to the NDPP. You remember Mr. Matabuche gave, I think, a very clear indication or evidence about the powers of the public protector to refer. This is another thing that might be as confusing as the CX thing. The power of the public protector to refer a suspected criminal conduct to the NDPP, as opposed to saying that you are saying the person must be charged or convicted or sent to jail or whatever. You refer it to the NDPP, and if they find nothing, they find nothing. You would that's got nothing to do with you. You would have discharged your duties, correct?
That is correct.
Okay. Just like when you refer something for amendment to Parliament, it's their business whether they get the sufficient majority or don't get it. You would have discharged your duty once you've made the recommendation.
That's correct.
Right. Now, I then want you to have a look at, in the spirit of scrutinizing, and I use that word advisedly, because I will use it, Chair, when we deal with the issue of whether judgments are here to be rubber stamped or not. Such a notion would be foreign to the duty of this parliament, because the constitution requires this parliament to scrutinize things and not just inquire into them, and also to scrutinize the activities of the executive. But let's put that aside for now. I want to refer you to on this topic, on this particular topic, in relation to the CR17 matter, to the remarks made by the Judge President Mlambo in relation to this issue that we're discussing now, as to whether the public protector can make such a referral for alleged criminal conduct. Let's look first at what Judge President Mlambo said when in the matter involving President Zuma or the state of capture case. Let's go to bundle C, item 48, page 1643. Carry on. Paragraph 91. Yeah, okay. So this is what the Honorable Judge President said. I'm looking for my fourth eyes. Yeah, but it's fine. Fortunately, I have a note here. You'll have to take my word for it. It says, there is nothing wrong in either the Public Protector Act or Ethics, Public Protector Act or Ethics Act that prohibits the Public Protector from instituting another organ of, rather from instructing another organ of state, thank you, Chair, to conduct further investigation. And the Public Protector Act expressly empowers the Public Protector to obtain assistance in an investigation and so on. That's section 64C1. That's the one that Mr. Mataboge referred to. Remember that?
Yes.
All right. And so that was what the learned Judge President said in relation to endorsing Advocate Madonsela's remedial action against President Zuma, correct?
That is correct.
And do you agree with the Honorable Judge President's sentiment and Mr. Mataboge's version of the powers of the Public Protector?
Yes, I agree.
Yes.
Chairperson.
Thank you. But now,
maybe before you proceed
to the rest of paragraph 92.
No, I wanted to say.
Okay, I think let's do it like this.
Go
because
to paragraph 91.
91, yes. In fact, Chair, if you can just, for my own disability, I'll ask the Public Protector to read it out while I'm looking for my classes.
Yes. Paragraph 90. Go to fine. Paragraph 90 itself.
Yeah, carry on. 91, yes.
Yeah, 90. I just want to say, okay, go to 89, sorry. You see this, the language, history, purpose of section 182C makes it clear that the Constitution intends that the Public Protector have the power to provide an effective remedy for state misconduct, which includes the power to determine the remedy and direct its implementation. I think yesterday, I'm sorry, SC, just to, or you found your classes, but in my response, I wanted to say to you, we read this paragraph yesterday, but it was now in the, this is a Pretoria High Court judgment,
Yes.
remember, it was now in the, I think, or they took it from the Nkandla judgment, because remember I was
Yes.
saying the remedy should, the public protector, when they issue a remedy, they should also determine how that remedy should be implemented. And then the next paragraph, in fact, then you can go to 91, Tsepo. Indeed, 91 and 92, because 92, it's very clear, under section 6, subsection 4C, Roman figure 2, the public protector may at any time prior to, during, or after an investigation, if he or she deems it advisable to refer any matter which has a bearing on an investigation to the appropriate public body or authority affected by it, or to make an appropriate recommendation regarding the redress of the prejudice resulting therefrom, or make any other appropriate recommendation he or she deems expedient to the affected public body or authority. So indeed, this is how we've been working as an institution. And this also led us, just now, I don't know how much time you gave
No,
the chairperson.
Take your time.
This led us to a situation where we had to, it says during the investigation or after an investigation. Therefore, it doesn't stop us that during the investigation, like it gives us that benefit like the SIU, because when SIU, sometimes when they investigate, they can immediately refer some information to the Hawks or to any other to proceed. This also gives us that. Then also it gives us that opportunity that even if we have completed the investigation, one of the remedial action will then be the referral to that institution. And here it's clear that you can instruct that institution, you can also indicate or advise on how that remedy can be implemented. So we took it directly from the Nkandla judgment, but I can see even here it's
Reflected.
definitely reflected.
Good. Now,
And the notion, because sorry, Chairperson, the notion by some, I see some of the analysts or some of the people will think that sometimes when the public protector is still investigating, other organs of state cannot do anything. Yes, it's helpful because our investigation is so thorough, and the powers of the public protector, we can then accumulate a lot of information and just pass it through, because that's what we also intending, or we did in this instance. That, okay, because since this is not our mandate, we are referring it to you to look into this.
good. So and that's the point I'm saying. Firstly, you've even taken it to a higher level. So you would then, in the spirit of what Honorable Sukas is always telling us,
Yes.
you would have used the learnings from this judgment, and even better from the Constitutional Court in Nkandla, which you say says the same thing, in order to learn and fashion how you then conduct yourself going forward, correct?
Definitely, because if you check all our reports, we refer to those paragraphs from Nkandla judgment. We refer to the mail-in guardian judgment. We refer now to this judgment, because I remember after it was delivered, I was laughing that even the observations are now have a binding nature, and the issue of the fact that you need not complete the investigation. But the first stage of you having completed the conduct of the investigation is this different process. The report on that conduct is a different process, and then to take remedial action. That's what this judgment by Justice Mlambo said.
Yes. Now, I just want to then refer you just to show, I mean, for those who believe that judgments should just be taken at face value, that they'll end up having a headache. Can you go to bundle C, item 30, page 1127. Paragraph 189. Up or down? Right. Now, this is the same judge, President Mlambo. Now, same judge, different president. Different public protector as well. Okay. Now, he says, he finds here, now you have fashioned your conduct in relation to that president. And then here now you are asked to, you are condemned for doing exactly that. Can you read then what Judge Mlambo then says now this time? We also find
189.
189, yeah.
You can just go down. Oh.
Yeah. It is dealing with the same section 64C1. Maybe let's go further
Let's start from the beginning.
A bit.
Yes.
Yeah.
Paragraph 189. We are constrained to find that the public protector's issuing of the remedial action to the NDPP, coupled with her insistence when the NDPP queried her that she expected the NDPP to carry out her directive, displays, in our view, a complete lack of understanding on her part of the limits of her powers as provided for in section 64C, Roman figure 1 of the Public Protector Act in relation to matters falling under the NPA. We also find that she displayed a clear failure to grasp the meaning of the concept of prosecutorial independence decreed by section 32(1)(b) of the NPA Act. The PPA and the NPA Act are clear that she has no power to direct the NDPP to investigate any criminal offense and how to go about to investigate or how to go about doing this.
Yeah.
Hence, I said that anyway, this reflects because you dare if you do, you dare if you don't. And I, unfortunately, Honorable Sukras, wherever you are listening, we tried to put all these judgments as our guideline because, showing that we are a learning organization. Now we directly rely on the Concord judgment, which says how to take a remedy, you need to direct how it's implemented. And it was done in the Constitutional Court judgment, in Nkandla judgment. Now we do the same thing. And we are accused of not understanding, or I'm accused of not understanding my mandate. I'm accused of
failing to grasp
a legal issue. So hence my predicament now to ask myself, is this playing a ball or playing a man? And hence, normally I would have then the feeling that it depends who the public protector, and is that fair for a constitutional democracy like us? And what are we doing to the generation? Well, I'm one person who's concerned about them. We've got a lot of lawyers and law students who are still at the universities and everything. So I don't know, how do we explain this to them then, if you are dealing with me? But then what do they learn from this? Because I did what I thought it has been done before. Yeah.
Well, thank you. So I was saying that's just homework for those who think that judgments must be taken at face value. They will tell us maybe one day which one of those two judgments from the same judge should be chosen. Thank you, Chairperson. That's the next topic is too long.
Thank you, Advocate Mpofu. Colleagues, the time now is 5 minutes to 5. This is where we're going to pause for the day, but maybe to also indicate that though we're scheduled for tomorrow as well, we'll not be meeting tomorrow. The public protector has an important appointment tomorrow in the Pretoria High Court. So we will not be sitting as an inquiry. And again, we will not sit on Monday and Wednesday, not because of the public protector, this time because of Advocate Mpofu, the legal representative of the public protector, who have important matters on Monday and Wednesday in Pietermaritzburg, which means we will then resume, colleagues, from Thursday. And we are still finalizing the time so that we allow a little bit of space. So whatever time, if we start after tea or at lunchtime, we might have to go much later on the day on Thursday in order for us to allow for, because it's kind of back to back, and we will respect that. So that's what is going to happen. And also linked with that, Advocate Mpofu, we're going to expect that at least by Wednesday latest, if we can get the remaining portions of the installments, because that is going to help to determine other things. So I will be expecting by Wednesday to get the rest of the statement from yourselves. We have quite an extended long weekend to help us deal with some of those issues. They have to catch a flight, so I don't want to delay them any further for this evening, because I'm not sure if they are not there tomorrow, what will happen at that Pretoria High Court. With that, colleagues, this is where we're going to adjourn.
Thank
our
you, Chair.
meeting.
Just for the record, it's the Magistrates Court, but it is in Pretoria.
Oh, okay.
It's in
Not the
Pretoria.
High Court, not the High Court.
Yes.
Okay.
Thank you very much, Chair. We appreciate that, and we'll communicate about the statements. We certainly were also envisaging that the next installment should be due sometime next week. Thank you, Chair.
Thank you, colleagues. We will follow that up with our issues. Thank you. The meeting is adjourned. Thank you. ICT, please remove Honorable Mauta from the platform immediately. Immediately. Please remove Honorable Mauta from the platform immediately. Thank you. I was saying, and I want to repeat, that today, colleagues, it is the day dedicated, and I even made the point that is the last day with witness Bianca Mkhwebane even though it constitutes the first interaction with her. And the time that has been set for today between now and I has explained at the beginning until we finish at 8 o'clock will be the business of the public protector team, the evidence leaders, the members asking questions, unless all of those three categories I've mentioned would take an option of wavering their rights and not ask any question, that will be fine. But that's what is meant to be done for today. So I therefore want to indicate, Advocate Mpofu, there is not going to be a discussion on the correspondence, on the letters that were written by myself to Public Protector Mkhwebane or her responses. If there is a need to raise those, they will have to be done in writing. Today is meant for us to focus on one and one only issue. Is the questions to the witness, Mrs. Bianca Mvuyana. And so as I'm going to hand over to you, Advocate Mpofu.
Yeah, I want to raise a point of order, Chair.
Okay, let me listen to the point of order.
Thank you, Chairperson. Thank you very much. Chairperson,
before, Chair, can I raise a point of order before? Because
no, you can't raise a point of order on another point of order. Go ahead,
Chair,
Advocate Mpofu. It's not done, Honorable Zongola. It's not done. Go ahead, Honorable Advocate Mpofu.
Thank you, Chairperson. I won't be long, Honorable Zongola. Chairperson, you know, we're trying to deal with this matter constructively. We have a letter from you here, which is insulting, disrespectful, untruthful, and contains serious insults to the public protector and her legal team. We cannot proceed before that matter is dealt with and ask you to withdraw that letter. And I'm saying to you that, so that's an issue that we want to put on the table. You may or may not decide to withdraw, but you must at least allow us to raise that point. That's your prerogative, but you can't deny us the opportunity to raise that matter of serious concern, which is an insult to the dignity of the public protector in particular, even more than her legal team. And you wrote that letter unprovoked, and we want to raise it with the committee. The committee can then decide whatever it wants to decide, not you, because you are the subject of the complaint. Now, so that let's put that matter aside. I'm saying assume that we will be able to maturely get over that hurdle. Then I was just saying on the issue of the witness, I'm giving you new facts which you probably did not know, in fairness, which is that the